May I please, Your Lordship? Lordship, I beg to mention for listing of an civil revision petition, which was earlier listed on 17/9/2025. And as I am for the petitioner in this civil revision petition. Earlier, the respondent took the adjournment. Before Puja vacation, it was listed, and it was directed to list the matter after Puja vacation, but the same is not yet listed. And the question of injunction is there, Lordship. That is why I am praying
When do
for
you
it
want?
on 6/11/25, Lordship.
Okay, there, okay.
Lordship.
Your Lord, may I mention item 52, which is listed today? I'm requesting it to be listed at 2 o'clock today.
Why?
Your Lords, it's unlikely to reach today, and I'm from Delhi, Your Lords. Requires urgent
No,
consideration.
you have to wait for your turn.
So I'm just requesting that it's fixed for 2 p.m. Your Lords.
No,
May I please? My lord, on behalf of Learned Senior Counsel, Mr. M.Z. Ahmed, I beg to mention item 16. He is out of station. Letter of absence given. Kindly matter and taken up next week, my lord.
item number,
16, 1/6.
what is your name?
Clearly. I am appearing on behalf of Learned Senior Mr. M.Z. Ahmed.
You have informed the other side.
Yes, my lord, he has taken consent from the other side.
Heard Mr. P.
T.
T. Ali, Learned Counsel for the respondent, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent. He submits that he has informed the Learned Counsel for the appellant regarding his prayer for adjournment. The prayer is allowed.
My lord, next week.
Registry will list.
Obliged.
May it please your lordship, I beg to mention listing of a RSA matter, your lordship. It was last listed on 2017.
When do you want?
In this week, your lordship, it is in the order column, your lordship.
Okay. In this week on a date to be fixed by registry.
Your lordship,
No, date registry will fix. Okay, next week in a date to be on a date to be fixed by registry.
May it please your lordship, I beg to mention one SAO lordship. May be listed in the orders column lordship.
Next week.
Lordship may give it any.
No, registry will fix the date.
If I may, my lord, I beg to mention item 12. My lord, there's talk of compromise going on. My lord, I've taken.
You have informed the other side.
Yes, my.
Heard Mr. G. Imtiaz, Learned Counsel for the petitioner, who prays for an adjournment on the ground that talk of compromise is going on between the parties and there is a possibility of reaching an amicable settlement. He submits that he has informed Learned Counsel for the other side regarding his prayer for adjournment. Hence, prayer is allowed.
Deeply obliged.
May I please, my lord? My lord, I pray for listing of one transfer petition, my lord.
When?
If possible on Friday, my lord.
Next week? Next week on a date to be fixed by registry.
One another, my lord, MSC appeal for orders, my lord, were not listed for more than.
Next week.
Next week.
Obliged. May I please, lordship? Lordship, I beg to mention item number 25.
Yes.
The senior, the DJ Saikia father has recently expired.
Okay. Heard Mr. What is
H.
your name?
H. Nath.
A. Khan
H. Nath.
H. Nath, Learned Counsel for the respondent. Item number 25. You have any objection?
I don't have any objection.
Learned-
Let the matter come after 2 weeks, my lord. We have some urgency, my lord.
Okay. Learned Counsel for the respondent prays for an adjournment on the ground that the conducting counsel for the respondent, Mr. J.J. Sakya, is in bereavement. Considering the submissions, Learned Counsel for the petitioner does not raise any objection to the prayer for adjournment. Hence, prayer is allowed. Let this matter be listed after 2 weeks.
My lord.
May it please your lordship. Lordship, I beg to mention for listing 2 bail matters. The earlier bail was rejected by this court, lordship. So it may be listed tomorrow for motion, lordship.
No,
One AB and another is BA, lordship.
you have to pray before registry. Bail listing.
Lordship, kindly.
No, this court is not taking a criminal roster. Registry will automatically list it before this court. So registry will list it before this court. You pray before registry.
May I please your lordship? Lordship, I beg to mention item number 7.
Yes. What is your prayer?
My senior, Mr. S. Ali, has undergone a medical procedure recently. So he's
Heard
unable.
Miss, what is your name?
Jay Sharma.
Heard Miss J. Sharma, learned counsel for the petitioner who prays for an adjournment on the ground of medical urgency of the conducting counsel for the petitioner. Stop considering the submissions made by learned counsel. The prayer for adjournment is allowed.
My lordship, there is an interim.
The interim order shall continue till next day. Let this matter be listed. When do you want? In the next week on a date to be fixed by registry.
May I please your lordship? Lordship, I beg to mention item number 17. Lordship, one of the family members of the engaged counsel expired. So he is currently out of station. Lordship.
Item number?
Item number 17, Lordship. Kindly matter may be adjourned for a day and list the matter after 1 week, Lordship.
What is your name?
Teron P. on behalf of Mr. N.K. Kolika.
Heard Mr. N. Terongki, learned counsel for the appellant, who prays for an adjournment on the ground that the conducting counsel for the appellant is in bereavement. Stop. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed in the next week on a date to be fixed by registry.
My please, your lordship, I beg to mention for listing of the MSc application
When?
this week.
Next week.
Plus. My please, your lordship. Your lordship, I beg to mention 2 items, lordship, for listing.
Next week.
Next.
Item 55 from supplementary list.
What is to be done?
So all the matters, my lord, 3 my lord's bail hearings are also there, or maybe fix it, my lord, 2 my lord,
Okay.
because TCR is also there. and
Okay,
maybe
criminal matters at 2 p.m.
My lord, obliged.
Hold on, item number 1.
May I please your lordship? This is a transfer petition filed by the petitioner to transfer his own divorce case from Kachar Silchar to Sribhumi. Because earlier, his wife has also filed one maintenance case. Later on, he filed one divorce case at Silchar Kachar because his permanent.
Whether the other side has appeared before the trial court, will issue notice.
Lordship, this is my own case.
No, but other side has appeared, they may have objections.
But
Let the other side appear. At least notice be served. Heard Mr. What is the name? S. Das, learned counsel for the petitioner. This application under section 24 of the Code of Civil Procedure 1908 has been filed by the petitioner Shri Gopal Krishna Goswami, praying for transfer of FC within bracket civil case number 506/2023 from the court of learned, from the family court Kachar Silchar to the court of learned district and session district judge Sri Bhumi. Issue notice to the opposite party. The petitioner shall take steps for issuance of notice upon the opposite party by speed post within 7 days from the date of this order, returnable on 11th of December.
obliged.
Item 2.
Yes.
My lord, in this case, my lord, we have, my lord, a sale in this, yes, here, my lord, the order dated, my lord, 10/4.
Where is the impugn order?
The impugn order left will find it page 104 and 119. Two impugn orders. Sir. So one, start from my latest, my lord, 119, my lord. Oh, she- 119, that is the order. Order of the place. And 125 million, 119 and 125.
Which are the impugn order?
119 pages and 125. Two impugn orders. Same possible. Same possible.
Yes.
Yes, you know, in this case, my lord, actually, this execution proceeding was started, my lord. From my lord, the title suit number 76 of 1979. My lordship, the facts of this case, my lord will find, my lord, page 34. My lord. Page 34 is the, my lord, the judgment of the trial court. My lord.
Yes, you tell me the gist.
My lord, now in trial court, my lord, because a title suit filed by the other side in 1971, my lord, for the declaration of the right title in interest over the suit land, my lord. So, my lord, the suit was decreed,
And
seven except the
with whom the possession was,
possession was with us, my lord, in
so
respect of
recovery of possession was also prayed for.
three, my lord, the schedule 4 land, my lord, described in the plain file.
Okay.
Schedule 4 land described in the plain, my lord. Now, schedule 4 land, my lord, which we are occupying under the schedule 4, because schedule 4 is a big chunk of land, my lord. So our land is also situated there. My lord. So this land was granted, we got this land by virtue of a gift, my lord, deed of 23/3 to 1948, my lord, which was given by one, my lord, Sri Milanini Bose, in favor of our predecessor in interest, my lord, Sharolabala Rai Chaudhary, my lord. That lordship will find it page 34, my lord. In page 33 and 34, lordship of the trial court judgment.
Okay, thereafter,
Thereafter, my lord, so we are possessing the land, my lord. And my lord, in it's 1970 also, another 1 big of land was also gifted to her, gifted to the predecessor of interest by that Sorolabala Rai Chaudhary. That my lord will find it, page 35, my lord. So we are occupying the portion of the land. It's not that their land also situated, our land is also situated, my lord. So therefore, my lord, when the court passed the decree,
decree against, was passed against whom?
against us, my lord.
You were the defendant.
No, the decree holder is there. We are the judgment debtor.
Okay.
We are the judgment debtor. They are the decree holder. So, my lord, when my lord they paid for the original source, right and title, right title in interest was my lord determined, my lord, for a partition of the suit land, my lord, because in the suit land they are the co-possessors, my lord. So therefore, my lord, a partition was done. Their land was separated, my lord. Their land was separated, my lord. Then, my lord, after that, they filed a title suit of 76 of 1971 for declaration of right title interest and recovery of the possession, my lord, from us, my lord. Now, in that suit, my lord, save and accept the land, land covered by, my lord, the schedule 3 and 4 land, my lord. They are for right title international possession was declared in 76 of 1979, my lord. But the land situated in the, under the, my lord, schedule 3 and 4, delivery was not given to him because it was under our possession, my lord. So they filed a title appeal, my lord. In title appeal, the, my lord, the judgment and the decree of the trial court was reversed, my lord. So against that, my lord, we file a, my lord, a second appeal, my lord. Then the second appeal was also dismissed, my lord, on, my lord, 8/1/2016, my lord. Now, lordship may kindly look into page 88, my lord, the judgment of the second appeal, my lord. Here the case has been narrated in detail, my lord. Now I will take my lord. To page, my lord, 99 of the judgment, my lord, the, my lord, honorable, this honorable court, my lord. The honorable court discussed the factual matrix of this case in para 20, my lord. So, my lord, this our first, second appeal was dismissed in para 20, my lord, will find. Start short, my lord. My lord has got it. Para
Yes,
20.
yes,
Lordship, from the aforesaid decision of the apex court, it is thus clear that there is a finding of exercise undertaken by the collector under section 54 of the CPC for carrying out a partition of the revenue paying state in terms of a civil court decree is a ministerial or administrative act not involving further determination of right of the co-sharers in the immovable property. Contentious issues, my lord, if any, arising between the parties while executing decree would however have to be dealt with by the executing court in accordance with the provision of the CPC, my lord. So our issue is that, my lord, our objection was that, my lord, that our land is also situated, my lord, which is the gifted property, my lord, to us. We are possessing by virtue of a gift, my lord. So, my lord, we filed a application, lordship, the against which, my lord, our application was rejected, and we came before this honorable court. That, my lord, will find at page, my lord, 110, my lord. Two application has been filed by us. Lordship will find in 110. That was filed under, my lord, order 30/10/2. Lordship will find, and by virtue, by that petition, my lord, we prayed for, my lord, that call for the records of the title suit number 62 on 112, my lord, our prayer. Call for the record of the title suit number 62 of 71 and the TS number C35 of 1881 from the courtroom for the proper, complete and adjudication, otherwise adjudication, my lord. So we, by this petition, my lord, we call for the record of this title suit, my lord.
why, for what reasons
My
these
lord,
records
reason
were?
because, my lord, because since our land is also required, also situated there, my
But
lord. The court has to ascertain, my lord, whether we are encroaching upon their land or not. If
No.
it is not, our land should be
Court
separated.
will execute the decree.
Yes.
In the decree,
That, my lord, for that purpose, my lord, these, my lord, the records are required, my lord, because this suit was filed by them. All the suit have been filed by them.
required for what purpose?
My lord, required for lordship will find
For execution,
execution purpose, for determination, my lord.
determination in what?
Because, my lord, our plea is that, my lord. our plea is
Determination in what case? Which case?
In 76 of this case, my lord, in 76 of 76 title suit, 76 of 1979.
No, what remains to be determined when?
My lord,
This-
our land is also situated there, my lord. If your lordship look into this, my lord, the schedule of the land, lordship will find that this particular land does not cover their land only. Our land is also there because other lands are also there, my lord. So what we pray that the record should be called for and, my lord, for a proper adjudication, my lord. If their land is there, let them take, save and accept our portion of the land.
Proper adjudication in which proceeding? Again, further adjudication will. be done.
In title suit number 76.
That has already been disposed of.
Disposed of, my lord, but the thing is that, my lord, our possession in respect of the land, we said we are also possessing that land, my lord. A portion of the land, which is gifted to us, my lord. So the purpose of determination of that, we have no objection, let them take their portion of the land from that scheduled land, my lord. But while executing decree, our land should not be disturbed, my lord. So therefore, we prayed that there should be a proper adjudication of the matter. So, my lord, for that purpose, this application was filed. My lord. Now, lordship will find from my lord page 118, my lord. Lordship will find that is the letter certificate also, my lord. Schedule of the land. 357 is the, my lord, the Dag number, my lord. That is the Dag number of the schedule 4 land. And Patta number is 190. We are also, my lord, our land is also mutated there in the same. And BK Rajoli is our predecessor in course. Because the record of the execution, everything is not available, my lord. Even the court is also admitted. No record is available. On 10/4/2000 order, the court has passed
No.
page 104.
So what is the error in the impugned judgment, impugned order dated 28/9/2025? Where
lord,
the
28/9/2025, the court has said, stated that, my lord, lordship will find the findings of the court from, my lord, page 123, lordship. Here, there is a valid judgment passed by the competent trial court against the petition.
you have not assigned the reasons.
Where if the case record is, we have assigned the reason in the petition, my lord. That is accepted. Lordship will kindly see. Lordship will kindly see page 114. That is okay. Page 2. My lord, para 2.
Where is the description of the decretal land?
My lord, that will find from, I have submitted a, my lord, the already a copy, translated copy. My
No, in the decree which is sought to be executed,
yes,
whether decretal land is identifiable or it cannot be identified.
that is the requirement. That is the prayed
No,
for the
answer
purpose.
my query. Is it identifiable?
It
Whether, is there any doubt that it is not the decretal land?
Well, that, we said, my lord, yes. That should be identified. That is our whole object, my lord. Let them take their portion of land. We have no objection, my lord.
So they will take their portion only.
My lord, if your lordship see, my lord, this is the delay tactics. They wanted to ask the executing court to go behind the decree.
No.
If your lordship will see page 96 of the High Court judgment, my lord, I shall show only one paragraph, my lord. Since
No,
71 we
no,
have. had.
I'll come to you.
Pardon?
I'll come to you. Before that, one more order is there, which you are
Yes,
implementing.
yes. Now, another order lordship will find that page, my lord, 125 lordship. That, my lord, petition was filed for polling of the partition case, my lord, which was done by the revenue authority, my lord. Because the revenue authority has merits and bound, they have done. So this is required, this is also missing. My lord. Petition document. 114. That is the petition.
Which is the next impugned orders?
NP in order is 125 lord. May I read you?
This is also under order 13 rule 10.
Yes.
And that is for calling the PP case, my lord. Case number 30 of 1973-74 from the office of the district commission. Because that is the, by virtue of that PP case, land was partitioned, separate patta was created, my. So if this record is called out, everything will be, my lord, come to light. We are not saying, well, we are going beyond decree, court should go beyond the decree. But while executing the decree, my lord, our bona fide right over the land should also be protected, my lord. Possession should be protected, my lord.
Read this order, impugn order.
My lord, it starts from page 126, lord. The petitioner, sorry, my lord, this is from
Yes.
page 125. Both sides are represented. The petitioner, Sandeep Roy, has filed petition bearing number so and so. They under the read with section 151 CPC praying for calling for the case record of the PP case number so and so from the office of the district commissioner Kacha Silchar for complete adjudication of the case. The petitioner has pleaded that as per execution petition filed by the decree holder so and so, it appears that before filing TS number, he has filed PP case number 30 of 73-74 partition of his share of land which was carved out of from the second RS Patta number 11 and 19 of Pargana so and so, Lakhimpur out of total area of 17 biga 11 kathas and 3 chotaks. The petitioner further pleaded that after completion of the operation of said PP case, the DH got the land described in the schedule 2 of the execution case and thereafter filed a TS suit number 76 of 79 without continuation of the PP case, which he filed to demarcate the share of the land included in the schedule 3 and 4 of the execution petition. The petitioner further pleaded that the plot of land mentioned in the schedule 4 of the execution petition is the homestead land of the petitioner, which he has been residing along with others for more than 80 to 90 years. The petitioner further pleaded that the decree holder Madhusudan Kaur had filed a title suit number 76 or 79 without final determination of his share of the decree in PP case number so and so in order to grab the land mentioned in the schedule 4 belonging to the petition. The petitioner further pleaded that the name of the predecessor of interest is recorded against second RS Patta number 119, Pargana number so and so for in PP case number 30 of 73 of 74. The petitioner further pleaded that if the execution case is allowed to proceed without identification and demarcation, it will not be possible to execute the land mentioned in the schedule 4 of the executing petition. Pleading as above, petitioner has paid for pulling the case record of so and so in the office of the district commissioner Kachar for complete adjudication of the case. Then, my lord, the opposite parties filed written objection wherein they have stated that the predecessor of the petitioner Daniel Lai has arrayed a respondent number 10 of the TS number so and so representing title suit number Iman so and applicant number so and in RS number so and connected miscase number so and so, which was dismissed. The opposite parties further pleaded that as the RS 230 of 2000 filed by the petitioner or the petition RS number challenging the judgment or TA number was dismissed, the petitioner who claims title through the applicant number 8 has no right forcible to call for the record of the PP case now prove that he has a right over the and particularly when there is judgment passed by the competent court and view of the fact that executing court cannot go behind the decree. Third, learned counsel for both the parties. So it appears from the case report that the petitioner in the interest of opposite predecessor in interest of the opposite parties decree holders, namely so and so, filed title suit number so and so against the Sunil Kumar Datta and 9 others. The predecessor of petitioner Somodip, namely Daniel Lai, was also one of the defendant applicant judgment that are out of the 10 person mentioned above. In the court of assistant district judge 1, declaring of his right, title and interest in the plot of land more elaborately described in the schedule 1 of the plain, confirmation of his possession of the same and for recovery of the khas position by evicting the defendant from the plot of land more elaborately described in schedule 2, 3 and 4 of the plain. It is further appears that the suit was transferred to the assistant district judge number 2 Kachar Silchar, who decreed the suit party by declaring that the petitioner has right that interest over the plot of land more elaborately described in schedule 1 of the plan. He is entitled to recover the harsh position over the land, more particularly described in schedule 2 of the plan, but refused to grant possession of the plaintiff over the plot of land more elaborately described in Schedule 3 and 4 of the plaint. It further appears that original plaintiff challenged the judgment and decreed dated 12/11/1986, which was partly decreed in his favor before the district judge Kachar in PA number so and so against the legal heirs of the Hemandana Singho and others, and additional district judge Kachar Chilchor, to whom therefore is the appeal was transferred, allowed the appeal by judgment order later so and so, delivering first position of the Schedule 2 and 4 land to the original plaintiff. It further appears that the opposite party's decree holder plaintiff put the judgment and the decree later so and so into execution by filing title suit number so and so before the Court of Civil Judge number 2 Kachar Chilchor within 2 years of the opposite judgment and decree later so and so. It further appears that although the judgment an appeal before the Honorable Guwahati High Court filing the RSA number so and so challenging the decree later so and so passed by the additional district judge Kachar Chilchor, and although the title execution suit of 5 of 2005 was stayed temporarily by order dated so and so, but RSA number was subsequently dismissed on context on 8/1/2016, and on the dismissal RSA, the stay order of 3/2/2007 automatically got vacated. As there is a valid judgment passed by the competent trial court in number so and so against the predecessor interest of the petitioner, namely Daniel, declaring that the predecessor in interest of the opposite party decree holder, namely Ram Roshan Kodi, has right title interest over the plot of land more elaborately described in a schedule petition, and as such, the same has not been set aside by the Honorable High Court in RSA number 230 of 2005. I am of the considered view that the genuineness of the right title interest decree holder cannot be ascertained by calling the record of the from the office of the District Commissioner Kachar Chilchor. Even if the case record of PP number is called for and proof that the predecessor interest namely is recorded against partner number so and so, the same is not sufficient to prove that the petitioner had a right title interest over the decree, particularly when a competent court declared that the predecessor interest opposite party decree holder, namely Ram Roshan Kodi, has right title interest over the land more elaborately described in the Schedule 3 and 4 of the petition.
Where is the error?
My lord, the thing is that, my lord, because Schedule 4 land, my lord, we are not against their decretal land, my lord.
Where is the description of Schedule 4 land?
My lord, Schedule 4 land, my lord, I have filed a, my lord, copy of lordship, this my lord, decree, my lord, passed in title suit number 77. This is in the record, my lord.
No, in title appeal number, in the
Title-
title appeal, the Schedule 4 was the relief against in respect of Schedule 4 was allowed in title appeal.
Yes, yes, now.
So where is the decree in the time?
My lord, the Schedule 4 was described in, my lord, a decree itself, my lord.
Where?
My lord, in
Page number?
case number 76 of 79. I have filed,
No,
my
no,
lord,
where is that?
my lord, I have filed an additional, because that was on the record, man. When the matter came earlier, I filed mine. Want to be as an, I have a copy also, my lord. Yeah. Lordship, my lord. The lordship will Schedule 4, we are concerned with now Schedule 4, my lord. It's page 3, lordship. Lordship, and we see. Now, Schedule 4 lordship will see dark number 357/388 of total land measuring 2 acres bounded by lordship will see not remaining land of the dark. So there is other land also in the same dark. So what our prayer is very simple, my lord. Out of that particular dark, whatever their land is there, let them take, my lord.
That will only be taken. The decree is only in respect of 2 because 19 lecha,
Yes,
19 lechas or 1 katha 19 lecha.
Yes, ma'am.
Remaining land will not be covered under.
Yes. Therefore, my lord, the honorable court in the second appeal says, if there is a contentious issue, executing.
No, where is the contentious issue?
Contention issue is that, my lord, the land, my land, which is situated in a Schedule 4, my lord. Schedule 4 said that beyond that 2 acres of land, there is other land also. It's not that the schedule 4 land confined only. 2
No, I
bighas.
am not understanding one thing. When the
What?
decree is in respect of 2 bighas some kathas of land.
Yes.
It will be executed in respect of that area of land only. Remaining land will,
They did, while executing, my lord, they should not encroach upon our land. my lord.
how they will encroach?
But that clarification should be there. So let them, my lord, executing.
The execution will only be in respect of 2 bighas, 19 lecture, decretal land. Yes, Mr. Sayon.
My lord, actually, this, if you also see, my lord, in earlier suit, my lord, the partition was declared, page 96, my lord. That symbolic position has been given of this land. Para 15, page 96. You also got it?
Page 96.
96, second appeal, my lord, the judgment was second appeal. Internal page, my lord. But,
Yes. Para?
15.
Yes.
My lord, there is also no dispute that regarding the fact that pursuant to the decree passed in title suit number 6271, the collector had delivered khas possession of plenty over the entire suit land described in the schedule 1 of the plain, except the area land covered by schedule 3 and 4, in respect of which only symbolic possession was given to by the collector. Well, already, my lord, that has been identified in the earlier, my lord, portion, and it was given, symbolic possession was given to me. Such a recourse had to be allegedly taken by the collector, since the said plot of land, schedule 3 and 4 was found to be in possession of the different number 2 and 10, occupying dwelling houses and buildings standing there in the said plot of land. In the context of the facts, notice above, let me now answer the substantial question of law so and so. Now, my lord, this honorable court has decided it, my lord. Again, my lord, if you'll also turn to next page, my lord.
No, is there any dispute
No dispute,
regarding
my lord.
identity of schedule
No,
4
my lord.
land?
Symbolic possession has been given to me. Only, my lord, I could not get the khas possession. That is why I filed under suit.
How much area is covered under schedule 4 land?
Schedule 4 land, my lord, 2 bika, 1 kappa, 9
No,
level.
no, that's the problem, my lord.
That is, my lord, in the,
Where is that schedule?
my lord,
Schedule.
that my unfair had given that decree, my lord. 2 bika, 1 kappa, 9 level.
It is there, my lord. They are claiming that portion.
This is only
Not
you are
beyond
claiming. Schedule 3 and 4, in 6, schedule 3, 6 kata, 2 kata. And schedule 4, 2 bika, 10 kata, I think. This is 10 kata. So this has been done, my lord. So symbolic possession is given to me in the earlier part. Now, that is why, my lord, I filed another suit. And that suit was killed, my lord. Now,
Second suit was filed for recovery of possession.
possession. And that is why, my lord, against which, my lord, they have filed a second appeal. Because first appeal has been dismissed. And now, if you also see, my lord, I shall come. My lord, paragraph 14 at page 101, my lord, the second appeal.
Yes.
We accordingly decide the question referred against the appellant and in favor of the respondent by holding that section 54 contemplates civil code decree in respect of nature of the property described therein, in respect of the partition to be affected by the collector or the officer in accordance with the decree so and so and so. For the foregoing reason, I am consider opinion that the first appellate court was correct in holding that section 110 of the land revenue regulation will not have any application in carrying out a partition in terms of decree of the civil court. And as such, the lower and lower appellate court justified in reversing the finding of the trial court in respect of issue number 3 and 4 and declaring the suit for recovery of first possession of the land described in schedule 3 and 4 in favor of the plaintiff. So this is clear finding, my lord. This is a decree, my lord. And now they have filed the two applications. If your lawsuit see, is there any reason, my lord? that, I'm sorry. My lord, there is no reason why, my lord, they have filed these petitions. If you also see the petitions, there is no reason, my lord, page 114. Just they have called for the record. Why, my lord, necessary? Nothing. That is why trial court held. Petitioner has not assigned any response, reason why that question. That at page 119, the trial court has said, my lord, at page 119. So this is a must. Under order 13 rule in my lord. Your losses, ma'am, just see, my lord, one of the judgment, my lord, of our high court. My lord, upper high court, my lord. Just part 9. Page 2, my lord.
Yes.
Para 4. Court may send for papers from its own record of from other courts. The court may of his own motion or may in its discussion upon the application party to the suit send him for either records or from the court the record of any suit proceeding in this. Every application made under this rule shall, unless the court order directs, be supported by an affidavit showing how the record is material to a suit in which application is made, and that the applicant cannot without unreasonable delay or expense obtain a duly authenticated copy of the record or such a portion thereof as the applicant requires or production of the original is necessary for the purpose of justice. Nothing contained in this rule shall deem to so. So sub-rule 2 of order 10 quoted above indicates that every application calling for records of any other suit or proceeding from any other court has to be supported by an affidavit showing that how the records were material to a suit in which the application was made, and the applicant cannot without unreasonable delay or expense obtain a duly authenticated copy of the record from such portion or thereof as the applicant requires, or that the production of the original or necessary for the purpose. So this is, my lord, if you also see the application, it is absent. That is why trial court said, my lord, court, the petitioner has not assigned any reason. That is at page 119.
Yes.
119. Page 119, your lordship.
Yes, yes.
The petitioner,
Para 2.
para 2. However, has not assigned any reason why the aforesaid record is necessary. For what purpose will be served by calling the aforesaid case? My lord, I have got the symbolic position, my lord, in the earlier occasion. And now they are disputing, my lord, I do not understand why they have not disputed that. They are, my lord, filing a suit. Their suit was, my lord, actually not allowed in so far Schedule 3 and 4 is concerned. And now they have filed another suit, my lord. If you also see, my lord, they just to, my lord, delay the execution of the decree. Huh? They file another suit. They are just to delay the, my lord, the execution of the decree, my lord, they are doing it. This is a suit, my lord, again they have filed, and they have come to this honorable court, my lord. Justice.
How much land is there in Dag number 357, 388? Schedule 4 Dag. How much total land is there?
Total land, my lord, more, my lord. Total land is more, but my
But
land is.
decretal land is only 2 bighas.
Yes, 2 bighas, 10 katha.
Okay.
My lord, my land has been identified while partition case was, my lord, it was off. And I was given some symbolic position, my lord. I could not get the khas position. That is why I filed a second suit. And second suit, my lord, ends in the second appeal, my lord. So now with the question of, my lord, they have not given any reason, my lord, in the petition order 13 rule 10. Why it is unnecessary? Why they could not obtain certificate copy? Why original is necessary? Nothing has been there, my lord. If you also see the petition, nothing is there, my lord. To just delay execution case, my lord, your loss is entertained. And they filed a suit also, my lord, again. My lord, this is, my lord, their tactics, my lord, just to delay the execution of the decree.
No, by the description of the suit land given in the schedule
Yes.
4. Is there any doubt that it may not be identified?
Yes, it can be identified, my lord. It is identified. In the partition case, it was identified and polling question was given,
That is okay,
my lord.
but otherwise also boundaries are given.
Boundary are given, my lord.
Okay.
Now, Lordship, they have said, there is no ground has been cited, my lord. Lordship may kindly look into para 2, para 3, 4, 5, my lord, start from page 114. The honorable trial court say that the ground has not been given. It may not be acceptable, that's one issue. But the trial court cannot say that no ground has been given. Start from page paragraph 2, 3, 4, 5, 6.
Where are the grounds?
Lordship will see that it is to be stated there, Lordship will see is for that as per execution petition filed by para 1. Filed by the DH so and so, it is revealed that before filing title suit number so and so, DH filed a PP case number 30 of 1973-74 for partition of his share, which was carved out from the second arrest patta number 119 Porgona number Mauja so and so, part 1 of the total area of 17 biga 11 kata 3 chotas. Accordingly, after completion of the operation of the said PP case, the DH got only second schedule Schedule 2 land of the execution case and thereafter filed TS number 76 of 1979 without continuation of the PP case, which he filed to demarcate his share of land, which includes Schedule 3 and 4 land. And interestingly, Schedule 4 land is the homestead land of the petitioner appellant and there where they have been deciding since 1890 years old. Moreover, there are various houses, approximately 1820 numbers, including the top houses and the shop houses are in existence for last 18-20 years. That is now para 2. That is to be stated there. There are 2 numbers of the PMAI house and 1 government sanctioned toilet as well as a big pond within homestead land of the appellant in IE Schedule 4 with full knowledge of the decree holder, and the decree holder every day visit the shop house and homestead land of the petitioner applicant and others having every knowledge of their existence of homestead land since the time of the predecessor of interest of the plaintiff appellant, Binoy Bhushan Roy and others. That without final determination of the share of the DH he filed TS number 76 of 1972, grave the Schedule 4 and land of the appellant, and though homestead land of the DH is situated southern side of the homestead land of the appellant, my lord, that is important. Southern side of the land of the appellant and others in Schedule 4. That the appellant applied for second arrest patta number 119 Lokhimpur, where name of the petitioner and petitioner applicant were recorded, my lord. That I have already shown to my lord. That the one mutation certificate. 5, my lord. That further if execution petition executed through the process of the court, then whole homestead land, homestead and the shop house of the applicant and others will be demolished, putting the appellant and other financial loss of to due process because the suit was filed in 1979 and decree was passed in 1987. And by the passing of the time, collector demography schedule of the land already changed. So without identification demarcation, schedule land cannot be executed. That due to the aforesaid circumstances, it is very much necessary to call for the record of the PP case number so and so. One thing is that we have assigned the reason. Whether it is acceptable to the trial court or not, that is the one issue. But the trial court cannot say that we have not given any reason at all.
Okay. Heard Mr. B.J. Ghosh.
My lord, it is totally identifiable land and so identified already.
Heard
That is why
Mr.
my
B.J.
lord,
Ghosh. Learned counsel for
My learned friend has, my lord, submitted one decision, my lord. I also submitted one decision. He allowed that petition, my lord. That if there is any lacuna also for the interest of justice, relying on the.
which para you are relying?
Yes. Para, my lord, 10, 11. Reference to 2008, 1 GLT 468.
there is no lacuna.
Which judgment? This, there is no para 10, 11 in this.
Yeah.
Last para is para number 5.
It is there, man. It is there, Lord. Page 10, 11. Lord. Copy গুলো বাইর করো না কেন? Note take করো না নাকি?
What?
Executing court can, my lord, find out, my lord. Yes, because boundary is there. Boundary is there. Without that, it can be done.
Yeah.
The boundary is very much there. Because earlier PP case, it was found out. And they have admitted that their house is in schedule 4.
It is 10, 11. I'm sorry, my lord, just make some marking, my lord. This is not my copy, lord.
What is this 1011? What it says, 1011?
Then court said, my lord, that even if there is some lacuna also, my lord, I'm not saying there's lacuna because we have stated the reason. Whether it is acceptable to trial court or not, that is up to the trial court, my lord. That's this decision enunciated that if there is some lacuna also, as per decision of for the rendering the substantial justice, the court can call for the record, my lord. That is the, my lord, the ratio of the judgment, my lord.
What is the facts of this case which you are relying?
Lordship will kindly see. Judgment will answer like it. Answer the kind of thing. Yeah? No, no, no. You just have to put on any other. Oh, okay. My lord, will kindly, the facts of the case, lordship will, may I read the judgment, my lord?
No, no, don't read it. You just tell me the which point you are emphasizing. In this case, you have filed order 13 petition before an executing court.
Yes,
And what the judgment, what are the facts of the judgment which you are relying?
my lord, the lordship may kindly look into page, paragraph 3, my lord. That facts lordship will get. What we will find from there.
So, which where are you relying?
There are 3, my lord, onwards. Yeah? Now, my lord, lordship will say para 9 also, my lord. He is the factual matrix of the case, my lord. The our 1310 petition was dismissed. Now, my lord, submission of the other side, lordship will find it page para 9.
And what was held by the court?
Hold by the court, my lord, para 10. I have considered the submission of learned counsel for the parties and also produced the material letter discuss about suitable basis related to the approach road, which according to the opposite party plaintiff is about the land belonging to the petitioner defendant and is using this since 1988. But according to the petitioner defendant, such path does not exist at all. Which according to him is also evident from the report submitted by the circle officer in proceeding initiated by the opposite of a plaintiff under section 145 CRPC. The petitioner defendant, after closure of the examination of the witness of the plaintiff, filed the application under order 13 rule 10 CPC to call for the records of the said proceeding being case number so and so, which contains the report of the circle officer to probe the content of the said report. No doubt, after obtaining full adjournment for examination of the defendant witnesses, the petitioner defendant written statement also pleaded the existence of the such report submitted by the circle officer in the said proceeding initiated under section 145 CRPC at the instance of the opposite party plaintiff and also content of the said report, which according to the petitioner defendant reflect there is no existence of any approach road as contained by the opposite party plaintiff in the plaint under order rule 1311, my lord, para 11. The court has jurisdiction sent for the paper from his own record or from the other courts, either of his own motion or on his discretion of application of any of the parties to the suit. Subrule 2 of Rule 10 Order 13 provides that if the application made to call for the record be supported by the affidavit showing how the record is material. Here,
Whether writ has been issued?
My lord, yes, my lord,
The-
earlier, my lord, good, but they have filed this petition, that is aware.
So
My lord, it is identifiable, my lord, if your lordship see the schedule, it is fully identifiable. And in earlier PP case, my lord, similarly question was given to me. So executing court may direct find out with the revenue staff, my lord, the land which is not, my lord, schedule 3 and 4. Because we are not only for schedule 4, we are 3 and 4, both, my lord. They are only for 4.
Heard Mr. B.J. Ghosh, learned counsel for the day after tomorrow. Also heard Mr. G.N. Sahewala, learned senior counsel, assisted by Ms. K. Sharma, learned counsel for respondent number 1 to 4. Let this matter be listed for delivery of orders on past tarikh. 6th of November.
That judgment of para 12 and 13 also covered. It is more or less on the analogy. Applies those.
Yes.
May I please, Lordship, my lord, in this case, the petitioners have filed a title suit before the Court of Civil Judge, Senior Division, number 13/24, playing inter alia for declaration of right title interest and also for cancellation of 2 deeds. Now, the plaint, your lordship, will find at page 43, 43. And 49. There is the amended, the plaint was later on amended. And this is the amended one. At page-
You first tell me the gist of the case.
Yes, my lord. The petitioner has filed TS number 13/24 in the Court of Civil Judge, Senior Division, making the respondent number 2 and 3 as defendant number 2 and 3. Now, on 18/1/24, that is also, my lord, is required to be mentioned. On 18/9/24, subsequently, the defendant number 2 and 3 has filed 144 CRC in the petition under 144 CRPC in respect of suit land before the district magistrate, my lord. Subsequently, on
On a particular date, you need not to tell me the date. You
Okay,
tell
but
the
then-
facts.
subsequently he has filed,
Yes.
making Mr. Nurul Haq Majumdar as their advocate, and Mr. Abdul Sukkur Chowdhury is the junior advocate of, in that case. That case, 101/44 proceeding has been drawn. I have challenged that proceeding before the session judge,
144 or 45?
144.
Okay.
I have challenged before the session judge. Yes, session judge has stayed the proceeding. And later on, session judge has disposed of the matter, so disposed of the revision petition, dismissing that 144 proceeding. So, my lord, later on, what happened? This defendant number 2, this advocate, Mr. Abdul Sukkur Chowdhury, who was engaged in this, that in respect of that suit land, who filed 144 CRPC, my lord. He has filed a petition suit, TS number 163/24 for specific performance, my lord. Subsequently, in the same suit land, my lord. Now, in that case, 63/24, the advocate was there, Nurul Haq Majumdar, who was engaged in the 144 proceeding. And this Nurul Haq Majumdar, similarly, parallelly, he has filed also, my lord, WS and counter claim in my suit, that is 13/24. That there is no whisper that their suit land has been proposed to be sold to the advocate, that Abdul Sukur Chaudhary, my lord. Now, there I was not with party. Defendant was make the respondent number 2 and 3 were make the defendant in that suit, 63/24. No, that suit has been decreed on admission. Your lordship, I will take the judgment of that suit, my lord.
Okay, assuming that it is decreed on admission, then what is
Yes,
your
decreed
grievance?
on admission. Decreed, I was not made the parties, my lord. Subsequently, execution
That suit was for specific performance of.
specific performance. No transaction, nothing has been made. They have
Okay,
taken-
thereafter what happened?
Yes, after that, they have filed that execution proceeding, my lord.
Yes,
Then only the when police came, then I have came to know. Then I have filed petition under that section 97, 98 or that 101 that I have filed in the by filing a miscase. Now, in that miscase, I have also prayed for stay of the proceeding, that execution proceeding that has been stayed. Subsequently, that defendant that 2 and 3 has filed a miscase in my TS 13/24. That farmer suit has been disposed of. On that ground, my plaint has been rejected subsequently. So now,
so you are against the rejection order.
not against the rejection, whether that suit is maintainable, the suit for specific performance. Because there is no title, the title has been challenged in this suit 13/24. There was suit for whether the defendant who has filed a counterclaim in my suit, counterclaim, there is no,
No, which order you are impugning now?
that now that, my lord, order of that decree, my lord, in passed in 63 of,
That you have already put to challenge by,
no, they are. I
by
have challenged-
97 petition.
No, 97 petition, I have just right title and interest, but in this suit, that I can withdraw also, my lord. But whether this suit is collusive or not, my lord. If it is collusive, everything will go, my lord. If your lordship interfere.
No, if it is collusive, then you file a suit that the decree is obtained collusively for cancellation of, how you can come?
No, here also I can file it 227. No bar. Supreme Court says in either in original code or in appellate code or in revision code, everywhere I can file. Challenging that collusive decree, man. Everywhere that Supreme Court has said, my lord. So I have filed 227 because since I did not file, I have challenged their only right title in that execution proceeding. That can be withdrawn. That can be if my suit is not dismissed. Because everywhere, anywhere in the final, even in the, my lord, in any code, original code or appellate code or revisional code, I can file. So revision code, I can come under 227.
No, but for coming before the revisional court, there has to be an order.
Against the decree, the Supreme Court says against the decree, anyone can go. Again, because in that my suit, they were the defendant number 2 and 3.
Against a collusive decree
Decree.
obtained,
Yes, my lord.
against a decree obtained by collusion, you can directly come under 227.
Yes, my lord.
Show me the
Yes, ma'am.
authority.
Take note.
How this court will decide whether the decree is collusive or not? We don't-
Defendant's FIR, if the respondent FIR, they will say whether there is no transaction of money, my lord. Nothing is there, only that it has proposed to be sold to me and advance has been taken. So subsequently, they have issued 2 checks out of 55 lakhs. There no report, nothing is there in that they have submitted before the court. And they have also not made me
No,
party.
you have not understood, or I have not understood the para 22.
Yeah,
Read para.
Yes, my lord. In this, my lord, here the order has been obtained by fraud,
Yes,
my lord. It is the settled proposition of law that a judgment, decree, or order obtained by playing fraud on the court, tribunal, or authority is nullity and non-est in the eye of law. Such a judgment, decree, or order by the first court or by final court has to be treated as nullity by every court, superior or inferior. It can be challenged in any court at any time. in appeal, revision, read, or even in the collateral proceeding. So I have come here in the, by this 227. It's a superior court than that court, my lord. So I have come here in the revision. If your lordship interferes in that collusive decree, then everything will restore, my lord, my thing. And automatically that my miscellaneous petition filed declaring right title interest also will go on. If your lordship, my lord, dispose that.
Yes.
In the cost title, they have stated their claim has been rejected as per order dated 8/9/2025. Your lordship may come to the last portion of the impugn order, case 35 Miller.
No, that was my question. Which order he is impugning?
Apparently, they have come against the order dated 8/9/2005 and 2025.
He's saying he is impugning the decree obtained in
Yes, decree.
in 8/2/27 procedure.
Very clear, my
They
lord.
have
4/6/24.
Puts to the court, sir, under, request to the executing court under section 97 Miller for determining their rights. And section, and rejection of plaint is a decree, Miller. No revision lies. And appeal will be live before the district judge, Miller. Your lordship may come to section 2(2) of CPC, Miller.
That I agree, appeal. If in that way, if we go appeal, but I am not on that. Whether decree obtained is a collusive decree or fraud.
Fraud has to be established, Milord.
Establish, your lordship will establish the 227.
In 227, I will, you will reduce evidence.
Your lordship will interfere in the collusive decree, my lord. If they reply, let them show how transaction has gone for sale of that land. Whatever they have stated on admission of the plane, nothing has been examined by the court below.
They have filed.
That is superior power, your lordship held under
filed
Article
an application
227.
under section 97. Most interesting, they have not
Okay.
entered this application. Milord.
Assuming, accepting your argument
Yes.
that decree obtained, you are alleging that the decree obtained is
Collusive.
obtained by collusive and fraudulent
Fraud.
means.
Yeah.
You have other recourses. You could have challenged it by filing a suit.
That is, my lord, the Supreme Court is in anywhere I can find.
No, I want to understand. You could have challenged it by filing a suit. Then when the alternative recourse is available, why powers under 227 should be exercised? 227 cannot be exercised on drop of a hat. If you have other recourses available, instead of filing suit,
Your lordship has supervision power under Article 227. So decree, the Supreme Court what says there, if it is fraud or collusive. In any, that there also I can file a suit again, new suit, challenging, recalling that judgment and decree, collusive doctrine and decree. But that the same thing will come, my lord, that there, if I go there, if I file appeal also, my lord, nothing will come out because there I was not a made party.
you can file a suit.
But instead of suit, I have come here, my lord. Here also I can even go also, my lord, Supreme Court in 136.
Okay, you answer my
Four
que-
piece, my lord, 4 piece.
you answer my query. When alternative course is available,
Now, here the Supreme Court has given, my lord. Anywhere I can find. That para 22, anywhere,
not under 227.
anywhere. Anywhere I can find.
You give answer to my query by supporting authorities. I'm not. That my query is when it is alleged that the decree has been obtained by fraud or by collusive means, then whether And if the petitioner approaches the court without filing a suit, that is the recourse which was available to the petitioner. Whether
Yes,
the
your lordship
co-
may take the matter to day after tomorrow, Wednesday.
yes,
Wednesday is holiday, my lord.
Thursday, my lord.
heard Mr. B. Sinha, learned counsel for the petitioner.
5
Also heard, okay. Also heard Miss S.
Roy.
Roy, learned counsel for Kevitor.
Respondents number 5
All,
and 6.
all this
What the respondent number 5 and 6?
respondent number 5 and 6 / Kevitor. You are not impugning order dated 8/9/2025.
Here only I have come against the collusive deed. That's why, my lord.
Learned counsel,
Consider upon that, everything will go, my.
collusive decree under in title suit number 63.
Yes, of 24.
Stop. Learned counsel for the petitioner has submitted that the petitioner has preferred this revision under Article 227 of the Constitution of India against collusive decree obtained by the respondent number
2 and 3.
2 and 3 in title suit number 63
no.
slash
Respond number 5 and 6.
respondent number 5
5
and
and
6 in title suit number 63/2024.
4, my.
On a pointed query put by this court to the petitioner as to when an alternative mode of this redressal is available to the petitioner to challenge the alleged collusive decree obtained in title suit number 63/2024, whether it would operate as a bar in exercise of powers of this court under Article 227 of Constitution of India. The petitioner seeks some time to answer to the query. The prayer is allowed. Let this matter be listed on when 6th,
Thursday.
that is 6th of November.
All right.
Lordship, kindly peruse the last order, 2810.
Yes.
Okay. That point was raised, Lordship, whether that issue raised by the defendant, that was any observation or findings has been given by the learned trial court, Lordship. No observation has been given in the impugn order, Lordship. Regarding the change of nature and character of the suit, Lordship. I have raised that point that if the amendment is allowed, then the nature and character of the suit will be changed, Lordship. But on that issue, there is not any findings, Lordship, or any reasoning, Lordship.
But suppose nature and character does not change. If it does not change,
But he has,
And no observation has been. Whether under 227, this court can go into that question.
because under order 20 rule 5 lordship, the learned trial court has to give reasoning of each of the issue raised by the parties lordship. Order 20 rule 5 lordship. So he has to, as I have raised the point lordship, so he has to give some findings on it lordship.
No, but whether this court,
Yes, lordship.
while exercising 227, will act as an appellate court.
Yes, lordship. It will be going to be some answer.
If no substantial injustice has been done, then yes,
My lord, under Article 227, this honorable court is having the power of superintendence. My lord, when the amendment petition was filed, no doubt they had filed an objection to that. And they raised a question that this amendment will change the nature and character of the suit. Now, my lord, what was the suit? The suit was, my lord, suit for a specific performance of contract, declaration and a specific performance of contract. As against that, my lord, they had filed their written statement together with the counterclaim. Together with the counterclaim that the agreement which was entered into by the husband of the defendant is required to be cancelled. And that was the agreement, my lord, wherein the predecessor in interest of the defendant had received rupees 48 lakhs as against rupees 50 lakhs, my lord, 50 lakhs. So that was the suit for a specific performance of contract that the defendants are bound to act upon the agreement which was entered into between their predecessor in interest and myself, and they are to execute the sale deed in respect of 7 kathas of land, my lord, in my favor. In my favor. As against that, they have filed the written statement. Now, my lord, in between, and I was given in possession also. The suit was filed on 27/4/2023. I was given possession of that property, not by them, but by the predecessor in interest of the defendants. Now, my lord, they filed the written statement, and during the course on 24/6/2023, after 2 months, I was ousted from the premises. I was ousted from the premises. Then, my lord, I came with an amendment petition that I was in possession of. Forcefully, I have been ousted. I should be put in position when, at the time when the decree will be passed. That was my prayer, my lord. That was my prayer. Now,
put in position after the passing
after
of,
the filing of the suit,
no, what relief you sought for by filing amendment?
by filing amendment, only the relief which was sought for, my lord, is at kindly peruse, my lord, that page number 37. That is the amendment petition, order 6 rule 17. Prayer, a specific prayer, my lord, in that petition is at page number 52. Page number 52. It is therefore prayed that your honor may graciously be pleased to accept this application and be further pleased to allow the plaintiff to amend the plaint in the manner as stated in paragraph number 6 of this application and to file the related documents in the suit, and also be pleased to allow the plaintiff to implead Shri Govind Kumar Chaudhary as performer defendant number 5 in title suit number 11/2023 and or pass such other order of the order that your honor may deem fit and proper in the facts and circumstances of the case. Now, for this paragraph number 6, I would have to take my lord to page number paragraph number 6 is page number 45, my lord.
Page 25.
Page 45, my lord.
Yes,
There are 3 sub-paras. That the proposed amendment.
this is sought to be included after amendment.
This part, my lord, that at the end of paragraph number 6 of the plaint, the following lines is required to be inserted. That is, it is in the inverted comma, my lord. It is in the inverted comma. It goes up to paragraph, page number 46 and page number 46. 6.
Who dispossessed you?
I mean the present defendant. But I was put in position by the predecessor in interest of the present defendant. Regarding disposition, in paragraph number 6, I have mentioned, my lord.
And what was the prayer portion, amendment sought in prayer portion?
Yes, that is my lord at page number 47. Page number 47, that's sub clause 2. And then my lord, this 3 is there. Regarding that, directing the defendants to deliver the position, my lord, at page number 51. In the prayer portion,
Yes.
in the prayer portion of the plaint, after prayer number 3, the following prayer is required to be added as prayer number 3A in the following manner. Directing the defendants to deliver the position of the shoot land to the plaintiff, and on their failure to do so, then the same may be recovered by evicting the defendants therefrom, and the plaintiff be put in possession of the shoot land. This is the prayer.
But suppose your main prayer fails, the
Then this prayer will also fail along with that main prayer.
so
my lord.
this is a consequential
Yes.
relief.
Yes. Consequential relief, my lord. Because, my lord, in a suit for a specific performance, as they have failed to execute the sale deed in my favor, that's why I have come to seek the redress from the honorable court. Now, my lord, if they are not executing the sale deed in my favor and not putting me into possession of the same, then it is also the duty of the learned trial court, executing court, to put me in possession of, because it is a suit for a specific performance, which has.
Position after giving you main relief.
Yes, my lord.
Suppose court comes to the finding that
I am not entitled
and
to.
you are not entitled,
Then
then
this relief will also go?
go.
Yes,
So
my lord.
this is a consequential relief
Exactly, my lord.
to which you would have otherwise entitled to
Yes, my lord.
in case of your
Suit.
getting the decree in this suit.
Yes, my lord.
So what is your submission that the trial court failed to consider their submission that
My lord, yes, my lord, they have mentioned in their objection that the nature and character of the suit will get changed. They have failed to explain before the learned trial court, my lord, that in a suit for a specific performance of contract, when there is a written statement come counterclaim, how the nature and character of the suit will get changed. They have totally failed to, because it will remain as the suit for a specific performance of contract.
and the
declaration
relief which we are seeking,
is under the umbrella of the specific performance of contract.
that is in the nature of a consequential relief only.
Exactly right.
In fact, in their plaint also, they have stated that position was handed over to them by verbally lordship. No position was given to them, lordship. Their statement in their plaint, lordship. Paragraph 5, lordship. That on the very day of execution of the sale agreement, the husband of defendant number 1 and father of the defendant number 2, 3, 4, so and so verbally handed over the position of the suit land to the plaintiff, lordship. Yes. And lordship, by way of amendment, not only that prayer, lordship, their prayer is to bring some documents, lordship, which are not related to this case, lordship. This is earlier, lordship, not related to this agreement, lordship. This agreement was executed as per them, lordship, on 18 to 2021. They want to bring some document which was executed between some other person, lordship, in the year 2014, lordship. And lordship, they want to implement one person also, lordship, who is not related to this, lordship, because lordship, can you see the amendment?
Where this implement is sought,
Yes, lordship.
My lord,
implement of Ms. One
because.
Govinda Kumar
Yes,
Chaudhary.
because in the year 2014, there was an agreement between the predecessor in interest of the present defendant with that of Mr. Govinda.
Not related to this agreement, lordship, or this sale.
Related to the suit property.
Some other, with other person, lordship.
No, with the suit
Whose son,
property.
lordship, lordship, can you see paragraph 5, page 42 of their amendment petition, lordship. Page 42.
Yes.
May I read that part, my lord?
Yes.
That the petitioner plaintiff begs to state that in paragraph number 6 of the plaint, the petitioner plaintiff has stated that after taking possession of the scheduled land, the plaintiff fenced the entire scheduled land all around with bamboo fencing, installed a crusher machine, and made a small Assam type room for office purpose therein, and has been possessing the said land peacefully and uninterruptedly since then. Whereas the defendant in their written statement and counterclaim have contended that they are possessing the shoot land since long and that the plaintiff has no right to dispossess the defendants, counterclaimants here. Here the petitioner plaintiff would like to bring to the notice of the Honorable Court that after filing of title suit number 2311/2023 and to be specific on 24/6/2023, when the staff of the plaintiff, namely Nandu Tanti, who had been residing over the shoot land, went out at about 10 a.m. and after some time when he came back, he found the gate of the shoot land was locked, and on inquiry by him, he came to know that the defendants had locked the gate. The defendants did not allow the staff of the plaintiff to enter into the shoot land and threatened him with dire consequence. At that time, the plaintiff was out of station, and her staff could not inform the plaintiff immediately, and on her return, after a few days, the plaintiff filed an FIR before the concerned police station, that is Dergaon Police Station, regarding the said incident. It is stated that in this way, the defendants illegally dispossessed the plaintiff from the shoot land and took over control of the stone crusher business as well as of the shoot land, and hence it has become necessary to bring on record the said subsequent development and seek appropriate relief from this Honorable Court by amending the plaint. That apart, very recently the plaintiff has been handed over with certain documents relating to the stone crusher business by her son, that is Govind Kumar Chaudhary, and Shri Ajay Kumar Chaudhary, which said documents being misplaced were not traceable at the time of filing of the suit, and for which the plaintiff was not in a position to bring to the notice of her counsel regarding those documents and the facts emitting from the same as to incorporate in the plaint. The documents which the plaintiff has subsequently come to know. The documents which the plaintiff has subsequently come to know, which was not in her possession, is an agreement for lease bearing deed number so and so dated 4/2/2014, coupled with a deed of a special power of attorney bearing deed number so and so 2014, standing in the name of Shri Ajay Kumar Chaudhary, together with two numbers of deeds of general power of attorney, one bearing deed number 49 and another bearing deed number 50, both dated 12/2/2021, registered on 18/2/2021, standing in the name of Govind Kumar Chaudhary, and one agreement for sale bearing deed number 43, dated 17/8/2020, registered on 18/8/2020, executed in favor of Shri Govind Kumar Chaudhary for the stone crusher unit, all of which were executed by the seller Shri Hiteswar Saikia and are related to the land and the stone crusher business. And in order to bring on record those documents and the facts arising therefrom in the plaint, it has become necessary to amend the plaint in the manner as indicated herein below for the ends of justice. My lord, prior to entering into agreement for sale with me, these were the persons who were holding the affairs of that land. These two persons holding the affairs of those land. My lord, there is nothing wrong if I am citing some other incidents of the past when I have been evicted from that premises. Because my agreement, my lord, is of the year 2021.
18/2/2020.
Yes, my lord, this page number 80 will speak for itself. It is a registered document, my lord. Page number 80, they have already given that document, my lord.
But these documents, Lordship, these are not related to the present agreement, Lordship.
Okay,
It's
then
after-
this will be discarded, my lord, at the time of evidence.
And Lordship.
They
that-
they will get the ample chance, my lord,
And also
to
if there is
cross-examine.
record, Lordship. Why implement is required, Lordship, that particular person? He is not the party of the present agreement, Lordship.
Present agreement is of 12th of February 2021, my lord. It is at page number 80, my lord. And that is the agreement for sale. And it is a registered deed of agreement, my lord. Page 80, my lord. And this agreement was executed by the predecessor in interest of the present defendant. And my lord,
Okay.
registered document itself is having its own genuineness. Unless otherwise proved by the defendant that it is a forgery. They have already come up with the counterclaim, my lord.
Yes, anything? You, anything else?
At that point, Lordship, I want to place two judgment, Lordship, regarding any findings, Lordship, or any reasoning, not giving of any reasoning, Lordship, I want to place two judgment.
Moreover, my lord, one thing I would like to submit, my learned friend will of course give the judgment, judgments are the ratios. That issues are yet to be framed, and I am yet to file my written statement against the counterclaim. That opportunity is already given. Issues are yet
Order
to be.
20, Rule 5, Lordship, paragraph 9, Lordship, 1998, 2 GLT, 203, 1998, 2 GLT, page 203, paragraph 9. Another two judgment, Lordship, one is in the year 2020 and 2024, Lordship. I have marked, Lordship. Paragraph 2 and 3, and another is paragraph 17, Lordship. I have highlighted.
On the same issue.
This is the judgment passed by our High Court. Para 9.
This is judgment passed in an appeal.
Yes.
My query is
Yes,
that,
Lordship, that.
that under
227.
227, can I act as, suppose the judgment is erroneous on some count, but it has not resulted in substantial injustice because issues are yet to be framed. Written statement against counterclaim is yet to be filed. If there is any irrelevant materials are brought in by way of amendment, you can answer to that.
Then Lordship, kindly take up the matter on Thursday, Lordship. I will place the authority, Lordship, on that point. On Thursday, Lordship.
No, that was my main query.
Yes.
Yes, my lord. On that day, the honorable court's query was.
That 227, my understanding is jurisdiction is very limited. We cannot interfere in each and every.
Aspect of the matter. Correct. Well, my lord, this
In-
statement is not relevant because order 20, rule 5 speaks of when the issues are framed on the disputed facts,
Yes.
and then the question will come, my lord. And that too after the decree is passed. Here, my lord, the issue is yet to get framed. Issue is yet to get framed.
Lordship, Thursday, on Thursday, Lordship, I will place that.
What's the quick cover?
Yes.
My lord, I'm one thing is to be submitted, my lord. From 5th of this up to 10th, I won't be there. my lord.
You
So
suggested
let
it,
it be, my lord, on Monday, 11 or 12,
11, 12. 12.
11.
That was my query actually. Heard Miss P. Bhattacharya, learned counsel for the petitioner. Also heard Mr. A. Sattar, learned counsel for respondents. Though learned counsel for both the sides made some submissions on various aspects of this case. However, as regards the query posed by this court by order dated 28/10/2025, learned counsel for the petitioner has submitted that she may be granted some more time to respond to the said query. The prayer is allowed. Let this matter be listed again on 12th. 12th,
11,
11.
11, 12, any day or 10 also.
Not 10, Lordship, 11 or 12. Lordship.
11th is a hearing day.
Right, your Lordship.
11, 11/11/2000.
Okay.
4 and 5.
Lordship, due to some personal difficulties, my senior is unable to appear today. Lordship, may kindly adjourn the matter for the day.
Injunction matter. Emergency is there, case is pending since 2020.
So you are conceding or opposing? Opposing the prayer for adjournment or conceding to their prayer?
Day after tomorrow.
Lordship, please up to 1 week, may kindly leave after 1 week.
Next week. Heard Mr. R. Ali, learned counsel for the petitioner. Also heard Miss, what is your name?
N. Pungan, Lordship, on
M?
behalf of D. Chaudhary.
M?
N. Pungan. N.
Write your name. Learned counsel appearing on behalf of Mr. D. Chaudhary. Learned counsel for respondent number 1, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent. Stop. Considering the submissions made by learned counsel, the prayer for adjournment is allowed. Let this matter when?
Next Monday, Lordship.
Let this matter be listed again on 10th of November.
If you have like it.
Item 6.
May I please, your Lordship? Lordship, the instruction is awaited, Lordship. Lordship may kindly grant us some more time to obtain the instruction.
What instruction? What was the instruction? In
Lordship,
which-
on the last occasion, my learned friend appraisal this court that the respondents have that the petitioners have filed a review petition. Lordship, that instruction we don't have
Oh,
against the dismissal of the title suit.
My instruction is that, my lord, they have filed on this appeal, my lord. I tell appeal number 6 of 2025.
Appeal.
Yes, Lord.
Appeal. Against the dismissal order, my lord. They have filed an appeal before the learned.
Now this CRPIO is also against that appeal and that dismissal order.
No, it's separate.
This
It's
is separate.
Different.
Petition. So Lordship may kindly grant us some more time, Lordship.
Just a minute. Which order has been impugned in this case? In this case, which order you are
My
impugning?
lord, in this case, my lord, the order for amendment, my lord. They filed an amendment petition before the learned trial court, my lord.
Yes,
And that amendment petition has been rejected.
okay.
Against this order, my lord, they have filed this civil division petition.
And what happened to the suit?
Suit might be dismissed for default.
Okay,
At the stage of evidence.
you
Lordship.
don't know.
No, Lordship, we
If suit is dismissed, then this CRPIO will not stand.
stand.
Yes,
Lordship.
fine.
That is why, Lordship, I'm
Okay.
seeking for some time, Lordship.
Heard Miss F. F. Ahmed, learned counsel for the petitioner. Also heard Mr. T. U. Loskar, learned counsel for respondent number 128. It is submitted by learned counsel for the respondents that he has been informed that this title suit in which the impugn order in which the order which has been impugned in the CRPIO was passed has already dismissed for default. And therefore, there remains no cause of action for filing this instant CRPIO. Sorry. On the other hand, learned counsel for the petitioner submits that she has no instructions regarding dismissal of the said title suit. Said title suit and seeks some more time to take instructions, to get instructions regarding as regards the fate of the title suit number.
50.
Title suit number 54/21 pending before the Court of Learned Civil Judge Karimganj. Considering the submissions, the prayer is allowed. Let this matter be listed after 2 weeks.
Clear.
Item 8.
May I please, my lord? My lord, in this matter, along with the FAO, one application is also filed for injunction, my lord. My lord, in the injunction, my lord, I pay for 2 weeks time for filing my objection, my lord. IA is for injunction under order 39 rule 1 and 2.
Okay. And in the main appeal,
Main appeal, my lord, there were delay already condoned listed for first time, my lord. So lordship may issue notice if my signature and addressing.
On, my lord, on previous occasions also, they were taking time on the ground of non-receiving of petitions, copy of petitions, etc. Although they have.
this
received-
IA number 1703 is for injunction.
It is for in fact stay. Not straightway an injunction because the
Stay
FAO
of-
is, yes, lordship, because this FAO is,
No, let us first admit the appeal
yes, lordship.
because there is no order.
So for the FAO is concerned, lordship, initially, the injunction was granted by the learned civil judge Tinsukia, which has been actually affirmed.
What is the matter?
Matter is lordship like this. I am the managing trustee. With my power of attorney, I have entrusted the present respondent, who was the plaintiff there, to manage the educational institutions run by the trust. The appellant number 1, defendant number 1 in the original suit. What happened, lordship? During the actually execution of the management, the present management, the present respondent, they have filed this suit stating that we are going to transfer the property, etc., etc. This is fact. Lordship may kindly turn to the plain paragraph 2.
No, in this suit,
Suit is not relating to immovable property. Firstly, lordship. Only to manage the institutions. One is the high school and the other is, and the other is.
the present respondent were the plaintiff in the suit.
He is the only person.
He is the, acha.
Yes, lordship. He is the only person who was entrusted with this under an MOU, lordship. The MOU, your lordship will find it at page 123.
No, before going to MOU, what relief was sought for by the plaintiff in the suit? Or
Plaintiff,
what relief was sought?
that is the thing, Lordship. Kindly turn to the prayer portion of the plain.
Page number?
Page number I am giving, Lordship.
60, my lord.
Uh,
60.
6. It starts at 6:1. Declaration that the plaintiff has acquired valid and enforceable right having legal authority over and in respect of the suit property under the memorandum of understanding. So
What is this suit property?
Yes, suit property, I am coming to that, Lordship. That is why I wanted to take your Lordship to memorandum of understanding. Let us begin with this point, Lordship, at this stage. The next prayer is, Lordship, for declaration that the plaintiff is legally entitled to continue and control the management of the suit property. Lordship has got it,
Hmm.
page 62.
Yes.
Suit property and the defendants have no sanction of law to cause any interference thereto. This is the main thing, Lordship. For the declaration that the plaintiff is legally entitled to manage the suit property. This suit property means what? That is what I wanted to take your Lordship to para 2.
Yes, let us go there.
Lordship, the injunction portion, Lordship, is that prayer E, Lordship. Prayer D, they say that they are in actual possession and control of the management. In prayer E, Lordship, they have said that they are continuing memorandum. Sorry, I'm reading it completely. For declaration that the power of attorney executed by the defendant number 2 in favor of the plaintiff in furtherance of memorandum of understanding has continuing legal effect and force, and the plaintiff already giving effect to the same is legally entitled to act and continue. That means, Lordship, as if they are interfered with from continuing with the management of the property. That is what is the impression tried to be given by the plaintiff in the suit.
Yes.
Nextly, Lordship, prayer F, Lordship, for declaration that the revocation and cancellation of power of attorney dated 19/12/2018. This is the memorandum of understanding, Lordship. They have not given what is the revocation date or cancellation, Lordship. Declaration that the revocation of such and such. What is the revocation to be cancelled? That is not there in the entire plaint, Lordship.
The
Or-
revocation deed which they are seeking cancellation, that is not there.
Not there, Lordship. We have given him the power of management. Now, he said that
By referring to power of attorney dated 1912,
power of attorney, yes, Lordship. Power of attorney is 19/12/18.
is it a power of attorney or he is referring to memorandum of
Memorandum of
understanding?
Exactly, that is the thing. This is neither a power of attorney nor a revocation. It is the memorandum of understanding. This is what is the thing. Lordship may kindly turn to page 12, that is internal page 12, running page 63, where they want this injunction, from which the present appeal has cropped up.
Yes.
For granting perpetual injunction, restraining the defendants, their agents, employees, servants, associates, or any persons claiming through them, etc., from dispossessing or causing any sort of interference, intervention, hurdles in continuing the control of management of the suit property. Now, Lordship may kindly turn to para 2 of the plaint,
Page number?
giving Lordship. This will be Lordship 54. 53, Lordship, 53. Sorry, the very first paragraph. That the Learners Education Trust is a non-government educational institution having Learners High School and Learners Junior College, etc., with a residential boarding situated at Santinagar, such and such place, which are standing over a plot of land measuring 8 bighas in that number so and so, pata number so and so, and lordship, which is the subject matter of the suit property. Lordships, what is the suit property? That is the thing, whether these schools, colleges, or the property, landed property. If the management is their lordship, and we have tried to revoke it, or we have revoked it, for cancellation of which they have filed the suit. Nothing is there on record, lordship. They have never mentioned it, even in their plaint. First point. Nextly, lordship, what cancellation should be, what revocation should be cancelled by the honorable court? As the user lordship has rightly pointed out, it is in fact memorandum of understanding. If the memorandum of understanding is to be cancelled, lordship, the entire case goes. This is one thing.
No. Their plea, what I understand is that the power of attorney is revoked
Revoke,
by some deed.
some did.
That deed is required to be cancelled.
That did
But
not.
that deed is not before the court.
Yes, that is not there. Firstly, that is not there. But if we go by the vagueness of this paragraph, that is what I was submitting before your lordship. If
Now,
I-
any interim relief was granted to them in the suit.
was granted, finally lordship, that was made absolute. And lordship, the delay was because that the present appellant before your lordship was wrongly advised and filed the appeal before the learned district judge. So the time spent here has been condoned by this honorable court.
Okay.
Now,
Now, what relief you are seeking to, in this appeal to
lordship,
to
to set aside the
vacate,
order.
set aside that by which stay was granted.
Stay was done. Stay, yes, lordship. Because there is, firstly, there is no revocation deed to be cancelled. So memorandum of understanding still stands.
Where is the impugn order? Let us-
Impugn order is lordship at
Starts from page 10.
10 lordship.
Which is the
Here, lordship, at page 14, lordship, first, second, third para, your lordship will find that the OP number 2 has suddenly revoked the power of attorney. It is not understood, lordship, where from the learned judge below found it. Revoked by which? If a document is to be revoked, lordship, there must be a document to that effect.
So oral revocation.
Oral revocation will not, because lordship, if that is force or forcefully the management is taken, lordship, the case will be different. Here are references, lordship, of Dumduma PS case number, non-FIR case number. These litigations are there, no doubt. But for what, lordship? The WS will
What
speak.
what interim injunction was granted earlier?
Interim injunction was not to interfere with the suit property.
Suit
But
property
possession-
means management.
That is what is the problem. What is the suit property? If the schools are suit property, then the question of management will come. If the landed property over which the institutions are there, then the landed property will come. Here, lordship, I would like to just apprise your lordship to
Then we can hear this FO instead of this is ready.
today itself, lordship.
No, whenever you are ready, the other side is ready. Records would be necessary.
Yes,
No.
Yes.
Be necessary, lordship, with the record. Otherwise, so far as possible, I have submitted all the documents, relevant documents. Lordship, they have not filed any reply affidavit or objections, etc. in respect of anything. Lordship, one thing, if your lordship permits, I would like to press only one thing. Lordship may kindly turn to page 105. This is a petition where we made an application for vacating the temporary injunction. Actually, it should have been an interim injunction. Anyway, Lordship,
105. Yes,
just for vacating.
yes. Before the trial court,
Before the trial.
but ultimately that has been made absolute.
Ultimately, that has been made absolute. But
Em-
Lordship, here, the order to that effect on this petition by the trial court, Lordship may kindly see at page 108. 16 to 2023. Last but one paragraph, Lordship.
Yes,
The learned counsel for the plaintiff also submitted that the plaintiff proposed to settlement on payment of rupees 2 crore 45 lakhs. This is what is very important, Lordship, because the no irreparable injury can be actually assumed or presumed, Lordship, unless the immovable property is involved. If for the management, Lordship, what they have invested for the management, they want this much of amount. Lordship, the basic principle of injunction is that if the loss can be compensated in terms of money, Lordship, no irreparable injury can be presumed or assumed, Lordship. In such cases, no injunction should have been granted by the learned court below. This is the recorded thing, Lordship, as per record. If the compensation can be made in terms of money, Lordship, then the injunction should not have been. So that's why,
now your IA has been filed for stay of the impugned
yes,
order.
Lordship. That is the reason if they find this much is the amount, maybe I cannot
Then this is to be heard finally.
finally, Lordship.
Because my lord, since 2018, the management of the affairs is, my lord, managed by the respondent, and these are those.
No, when can we finally hear this matter?
Lordship may fix after 2 weeks. In the meantime, I will file my objection because my lord, there are various documents by my lord which are not filed along with the FAO, which will be required for my lord deciding this FAO, my lord. Because number of documents are relied, my lord. Or otherwise, Lordship may call for the scan copy of the TCR of Miss J case, my lord. And then Lordship may fix a date, my lord.
Mijay case has already been
Already
disposed
been
of.
disposed of, my lord. So a scan
Mhm.
copy,
Lordship, in mistake cases, your Lordship knows that the entire documents are relied upon from the suit.
Yes,
So we
those
have
cases.
issues merely with the.
It will not be
discussion,
helpful.
Lordship,
No help.
Lordship will not get any document to that.
So we'll call the scan copy of the records
yes,
Lordship, please.
and fix it after 2 weeks for final hearing.
final disposal, my lord.
20th, Lordship, that is the Thursday. for
Okay.
the-
You are not pressing the IA
I-
at this stage,
Sir,
but he is seeking time for filing objection against IA also.
long back, Lordship, since August, this is there for that.
My lord,
After even furnishing copy, they have been submitting or saying that they have not received
lord,
copy,
copy-
they have also been filed.
copy-
Anyway,
I
it
have
is up to your Lordship, Lordship. So
copy I have-
Heard Mr. L. Talukdar, learned counsel for the petitioner. Also heard Mr. A.K. Gupta, learned counsel for, how many petitioners are there? Learned counsel for, sorry, appellant. Also heard Mr. A.K. Gupta appearing for
So
the sole,
we have appellant's Lordship here.
sole respondent.
We have
This,
defendants there.
okay. This appeal under order 43 rule 1 within bracket R of the Code of Civil Procedure read with section 104 of the said code has been passed by the, has been preferred by the appellants impugning the order dated 25/2019 in Ms. J case number 63/2019 in connection with title suit number 30/2019 passed by Learned Court of Learned Civil Judge Senior Division Tinsukia, in which the by which the trial court made the ad interim injunction granted against the present appellants in the aforesaid Ms. J case as absolute under Order 39, Rule 1 and 2 and 3, read with Section 151 of the Code of Civil Procedure. Learned counsel for the appellant has submitted that the appellant has also filed an interlocutory application, that is IA Civil number 1703/2025, wherein he has sought for the relief of stay of the impugned order during the pendency of this appeal. Learned counsel for the respondent has submitted that he may be granted some time to file a written objection against both the sorry. Both the appeal as well as interlocutory application. Stop. After going through the records, this court is of considered opinion that that instead of considering the interlocutory application at this stage, this appeal may be disposed of after hearing both the sides, learned counsel for both the sides, on the next date fixed. Stop. Hence, let this scan copy of the records of Ms. J case number 63/2019, along with the scan copy of the records of title suit number 30/2019, be called for from the trial court registry to take steps for requisitioning the aforesaid scan copy. The respondent may file written objection, his written objection without fail before the next date fixed. Let this case be listed again on when?
28 is Thursday, Lordship.
20.
Your Lordship's convenience.
20
November,
November
if convenient for all concerned parties.
for hearing, for
Court is ensured Lordship hearing.
if record arrives, we will hear. Otherwise, we'll see what can be done on that day. 20th November for hearing.
Public.
I didn't mind. Please, Lordship. Lordship, IA number 2897/23 was disposed of, Lordship, in this matter. Containing a delay of 482 days subject to the payment of 5,000 of cost, Lordship. That we have submitted before the.
You have paid the,
We have paid the cost, Lordship. Also, Lordship, under section 30 of workman compensation, we also submitted the statutory amount for preparing the appeal, Lordship.
how much?
Lordship, it round figures to 9,27,960 rupees.
What is the statutory amount which is required to be deposited?
Under section 30. If I may read, Lordship.
Yes.
provided that further that no appeal shall lie in any case, section 30 lordship, shall lie in any case in which the parties have agreed to abide by the decision of the commissioner or which the order of the commissioner give effects to an agreement come to by the parties, provided that no appeal by an employer under clause A shall lie unless the memorandum of appeal is accompanied by a certificate by the commissioner to the effect that the appellant has deposited with him the amount payable under the order appealed against. So lordship, the amount was, full amount has to be paid. That full amount we have made the payment.
You have deposited.
Lordship, that
Yes, you have anything to say?
will be admitted lordship.
We'll admit the appeal.
My lord, we have filed this appeal against the award passed by the commissioner. My lord, the provision of law is very clear. My lord, this appeal is not like the other regular appeal.
Substantial question of law is required.
Yes, my lord, condition is there. They can file the appeal against the award passed by the commissioner
Employees,
if there is substantial question of law is involved in the appeal.
yes.
Number one. Number two, my lord, in the appeal, they have to show that the findings of the commissioner are perverse. And findings of the commissioner, they can say perverse only when the findings are found that they are not based on evidence on record. Or
Where is your substantial question of law?
Lordship, that plea we have taken in the main appeal, lordship. That may be heard on my, also lordship, the senior leading is not available today, lordship.
No.
So, lordship, this matter may
we have checked, my lord, we have gone through all the grounds they have taken in the main appeal. They have failed to formulate any substantial question of law. Less to talk about substantial, my lord, even no ground they have taken relating to any law. They have simply said, we are not entitled.
Lordship, we have taken the plea that evidence on record was not taken into consideration, lordship. Also, lordship, they have failed to establish the fact that the deceased person was an employee of the railways, or he was working under some contractor. That aspect also they failed to appreciate that they failed
No,
to establish. that
but
he was
you have
working under
to-
Some contractor.
Where is the substantial question?
Yes.
But like section 100 of CPC, is there any requirement of stating the substantial question of law in the memo of appeal?
My lord,
In 100, there is a specific requirement.
perhaps.
It is not there in 30.
My lord, perhaps we'll go through the provision in the CPC, but before that, this appeal has been filed under section 30.
Yes,
Of the-
where is the, where? No, my query is,
Yes, my lord. It is in section, your lordship will find in section 30.
so there has to be a,
Proviso, my lord, I am referring to
No,
the
no.
proviso.
if we read that proviso, so there has to be a statement in the memo of appeal that this appeal involves a substantial
Yes,
question
my
of law.
lord, that's what I.
That statement is absent in,
Yes,
then this appeal is not maintainable. Unless you make a statement to that effect,
the first proviso. your
because
lordship will-
compensation was more than 10,000. How much compensation was?
About 9 lakhs.
9
9
lakhs,
lakhs
lordship,
plus.
9 lakhs 20.
9 lakhs.
Yes.
So if the quantum of compensation is of more than 10,000, then unless a substantial question of law is involved, appeal shall not lie. The question of maintainability is there.
Yes, my lord. That is what we are submitting before your lordship, before admission. This question your lordship will examine.
Yes.
In that case, Lordship, records may be called for Lordship as we have relied
No,
on the
no.
aspect. Lordship,
With unless there is a plea in your in your memo of appeal that we'll hear, you're ready, we'll hear this on the question.
Ready, Lordship.
Okay, come ready. Let him, we will fix it on the question of maintainability. Heard, Mr.
Why Borbia Lordship?
What is your name?
Why Borbia Lordship?
Why Borbhuya,
Appearing on behalf of Mr. H. Gupta Lordship.
appearing on behalf of Mr. H. Gupta. Learned counsel for the, this is item number,
Nine.
learned counsel for the
NF
appellant. What is your name?
J Mullah.
Also heard Mr. J. Mullah. Learned, you are standing counsel.
No, Mel, I'm for the respondent.
Oh,
My friend is for the.
you are,
appellant.
you are for the appellant. J. Mullah, learned counsel for the respondents. Learned counsel for the respondent has raised a plea of question of maintainability of the instant appeal in as much as the memo of appeal does not mention, there is no statement in the memo of appeal regarding involvement of substantial question of law in this case. Therefore, he submits that this appeal is barred by the proviso to section 30 of the Employees Compensation Act 1923.
My,
On this, learned counsel for the appellants prays that some time may be granted and another date may be fixed for hearing the appeal on the question of maintainability on the plea raised by learned counsel for the respondent. The prayer is allowed when let this matter be listed in the next week on a date to be fixed by registry.
my lord, 11 November is the hearing.
On 11 November.
Can it be on 14th?
When? 14th. Okay, let it be on 14th now. 14 November.
Much obliged.
Wait, please, my lord. Regular first appeal, my lord. Against the impugned order dated, my lord, 16/6/25 passed by the learned civil judge, senior division, Lakhimpur, in title suit number 6 of 23. My lord may have the impugned order at page 84, ma'am. Judgment, sorry, page 84.
What is the value of the appeal?
My lord, the value of appeal is my lord, 11.
Why it has come to,
24 lakh 70,000,
not,
page 99, my lord. Title of a property, my lord. The basic fact in the case is that, my lord, we have been residing, the appellants, my lord, in the last 50 years, we have been residing in the said Schedule A property, my lord, which is in question. Now, my lord, the defendant numbers 5 and 6, my lord, they in collusion with the authorities, my lord, they placed their names in the official records, my lord, in 2015 only. That is our grievance, my lord. And the impugned judgment does not reflect upon the fact that we have been residing since the last.
what is the pecuniary jurisdiction of the court of district judge? Why this appeal has not been preferred before the court of district judge? Whether it lies anybody
Pecuniary jurisdiction. The district judge. 20 lakhs,
20 lakhs. This is beyond 20 lakhs.
24 lakhs.
Okay, okay. Heard Mr. P. R. Sharma, learned counsel for the appellant. Appellants. This appeal under section 96 read with order 41 rule 1 and 2 of the Code of Civil Procedure has been filed by the appellants impugning the judgment and decree dated 16/6
25 lakhs.
2025 passed by the Court of Learned Civil Senior Division, Lakhimpur, in title suit number 6/2023. Your suit was dismissed,
Yes, my lord. Our suit was
whereby the suit filed by the present appellants was dismissed. Stop. I have perused the grounds of appeal stated by the appellant in the memo of appeal and heard learned counsel for both and considered the submission of learned counsel for the appellant. This appeal is admitted. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post within 7 days from the date of this order, returnable after 4 weeks. Let the records of title suit number 6/2023 be called for from the trial court. List this matter after receipt of the trial court's record.
I PFO 1 and 2. Respond number 1 and 2.
Before that, heard Mr.
A Bhattacharya.
A. Bhattacharya appears as Mr. A. Bhattacharya appears for respondent number 1 and 2, as well as Mr. T. R. Gogoi appears for respondent number 3 and 4. No formal notice need to be issued to the said respondents. List accordingly.
I'm deeply obliged, my lord.
Lordship matter may be taken up at two lordship. The arguing counsel is in another court lordship.
What is the matter?
The plaintiffs an injunction was granted by the learned trial court lordship
In your favor.
in my favor.
They are here to vacate the injunction.
Lordship. This is an appellate provision lordship. Order 43 rule 1 R and suit value is 27 lakhs. So this court lordship.
Okay.
My lordship, they have raised some allegations in their appeal lordship. So I have to file my objection lordship.
Written
annexing
objection.
Written objection enclosing the documentary proof against those allegations lordship. So if your lordship grants me 4 weeks time, then in the meantime, I can file lordship. I have filed one caveat. Lord.
Is there any interlocutory application
Yes, lordship. I
for
is there.
vacating the? You will be filing objection in IA also.
I
Okay.
But kindly at two lordship.
No. We are issuing notice. We'll call for records. Records would be necessary.
of course.
Oh.
Lordship interim injunction was granted, granting us to permit the brick lane industry, lordship. We are the leaseholder we have taken the brick lane industry from the appellant, lordship. And it is admitted by the appellant also. So the learned trial court, after deciding 3 golden
No,
principles.
then
injunction
no,
granted.
not 4 weeks, 2 weeks time.
Lordship, they have abandoned the brick industry lordship. That's why we have filed our interlocutory application to stay the injunction order
There's
No,
web-
2 weeks, nothing will happen within 2 weeks. Let them file written objection. Mhm. Who is your senior? Okay. Let him
At two, Lordship.
add 2. We'll take it up at 2.
Lordship. He is here, Lordship.
Look at two lordship.
তুমি করে দাও না?
No.
I'll place everything lordship. Lordship, I will demonstrate how that illegal order has been passed. At two
Lordship is
lordship.
here, Lordship, it may be taken up right now.
They will be filing written objections.
So lordship, yes, they will file lordship, but before that lordship, I would pay for an interim lordship, stay of their order. I'll satisfy lordship.
For
Then
that,
in-
I have objection,
Then
Lordship.
in the
At two.
second half.
Second half.
For that
lordship.
only I have filed,
No,
Lordship, I want
he
to
can
file
raise objection,
objection.
lordship. She can raise the objection, but prima facie, I will demonstrate, lordship, how their illegal order has been passed. Let two, lordship.
In the second half.
Lordship. Already 10 minutes on.
Yes, it may
of
not
this,
be.
Lordship.
Then 57 from supplementary list.
This is your Lordship. Lordship, this is a statutory appeal under the MBI. And Lordship, in this case, the appellant company adduced evidence to prove that the vehicle did not have a route permit. Not only that, Lordship, the documents exhibited by the claimant, Form 54 as well as MBI report, there also the permit is not mentioned. But still the court held that, and the owner and driver did not appear. But still the court at paragraph 9 held that it doesn't matter if, yeah, so we are.
Heard Miss R.T. Majumdar. Learned counsel for the appellant insurance company. This appeal under section 173 of the Motor Vehicles Act 1988 has been filed by the appellant insurance company impugning the judgment and award dated 29/8/2024 passed by the Motor Accident Claims Tribunal, Kachar, in MEC case number 448/2018, wherein a compensation of rupees 26,05,000 along with an interest at the rate of 9% per annum was granted to the claimant opposite parties. This appeal is admitted. Issue notice to the claimant respondent. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondent by usual mode as well as by speed post.
This stage only AD Lordship, because usual the report doesn't come usually, and maybe
By speed post,
I don't know, speed post, they have changed.
yes. By speed post within 7 days from the date of this order, returnable after 4 weeks. Returnable on 8th of December. List accordingly.
LCR, TCR.
The records of the MSC case number 448/2018 be called for from the concerned MSC tribunal. List accordingly.
We have a IA Lordship, we can deposit 50%, but release may not be allowed much.
Release after they appear,
We
will
can
hear.
file a petition and all that, but it can be disposed of, this IA.
I heard Miss R.D. Majumdar, learned counsel for the applicant. This interlocutory application has been filed under Order 41, Rule 5 of the CPC, praying for stay of execution of judgment and award dated 29/8/2024, passed by report of passed by the Motor Accident Claims Tribunal, Kachar at Silchar in MSC case number 448/2018, whereby an amount of rupees, how much?
26 lakhs 5,000.
26,05,000 was directed to be paid as compensation to the opposite parties claimant. Learned counsel for the applicant has submitted that the aforesaid judgment and award passed by the Motor Accident Claims Tribunal Kachar has already been impugned by the present applicant by filing the connected MSC appeal number 491/2025. She further submits that the insurance company is also ready to deposit 50% of the awarded amount as a condition precedent for grant of stay of the execution of the impugned judgment and award.
If insurance company is not ready, but lordship may direct us to deposit. That is the, because if we are ready, then they will come and say ki we were ready. But in this case, we are not liable to pay anything. I have the judgments also. As condition to stay, lordship may direct us to deposit.
Stop. He'd like to continue. As this court is this court is inclined to allow this interlocutory application with a condition precedent that the insurance company shall deposit 50% of the awarded amount before the registry of this court, it is not inclined to issue notice to the opposite parties at this stage in this interlocutory application. Stop. Accordingly, this interlocutory application is disposed of with a direction that during the pendency of the connected MAC appeal number 491/2025, the execution of the impugned judgment and award dated 29/8/2024 passed in MSC case number 448/2018 shall remain stayed during the pendency of the connected MSC appeal, subject to condition that the applicant insurance company shall deposit 50% of the awarded amount before the registry of this court within 4 weeks from the date of this order. This interlocutory application is accordingly disposed of. Yes,
Ma'am.
anything?
Sorry, Lordship. Lordship, item 32, Lordship. And in this case, Lordship, service awaited Lordship, till that Lordship. In the dear Lordship, case step may be taken Lordship.
At 2.
Deeply obliged. To item 55. Sorry, Lordship. I could not have present morning, Lordship. See, this is the second level petition, Lordship. I am not on merit of the present case, Lordship. This is the third seated case, Lordship. And the case is pending for advance in the committee, pending for committee, Lordship. There's third seat has been late, Lordship, showing the present petition as absconder, Lordship. That is why they apprehend that they may be detained. Which they will appear on dates fixed on the 12/11/2025, Lordship.
Under what provision charge sheet has been did? 10.
Lordship, such it has been late, Lordship, under section 61, subclause 2, 189, subclause 2, subsection of BNS. 189 is added in the
Charge sheet, Lordship.
Yes, Mr.
Next one, order, Lordship, as per the board bench of our High Court, Lordship. Lordship will find it at the page, Lordship, 61, Lordship. Similarly situated case, Lordship. In that case also, a search sheet was filed, Lordship. The case was pending for appearance in the pending for committee, Lordship. In this case, Lordship, the coordinate bench was placed to allow the petitioners to go on period as bail, Lordship. Lordship will find the operative person at page 61, Lordship. Paragraph number 9, Lordship. 61, please. May I read it, Lordship? Here and 9. The petitions have been indicated as absconder in the search sheet. The case is stated to be at the stage of appearance and pending for committal. In my considered opinion, not much purpose may be served by keeping the accused persons in detention, provided their presence can be ensured and stringent conditions imposed to ensure that they do not harm any member of the informant site. Refusing bail to the petitioner at this stage might even delay the commencement of the trial. Therefore, despite the grave nature of the materials,
Where is the earlier rejection order?
Lordship, that Lordship will find it at page 51, Lordship. Sorry, Lordship, that is not 51, Lord, 33, sorry, Lordship, 30, sorry. 33, there are 30, Lordship. Lordship, find it, Lordship.
Yes.
Considering the fact that the petition number, the Falguni Pegu, petitioners of Bika Sorenses, Utpal Pegu, Anil Pegu, Hiren Kutu, and petitioners of the Sarna Tarak Pegu have been implicated by independent eyewitnesses in this case. Their PFO and is rejected. That was after perusing the case, Lordship. I'm not on merit, Lordship. They are ready to appear before the trial court.
No, not on merit. How will you get
Lordship,
second
Lordship,
anticipatory?
search it has been late, Lordship. And showing the present petition as absconder, Lordship. Well, that is my basic.
You appear before the trial court.
So, since Lordship, search it as late, showing the petitioner as absconder, Lordship. That is why they appear that they may be detained, Lordship. Kindly, I am relying on that order, Lordship, passed by the court bench, Lordship.
No,
I'm
that
praying
is
for a
not
similar-
binding.
That is true, Lordship, that is true, Lordship.
You have to,
They are ready to appear, Lordship.
yes, Mr. Basho.
The earlier rejected matter on 12/6/2025, then matter was pleased to pass the matter detail order after perusal of the CD matter. This matter, their implications are there, matter. Oh, matter, otherwise, matter call for the scan copy matter of the PCR matter.
No, no.
Because it is 12/6, or matter let him appear matter there matter. Because matter this is a case matter where matter all the other his implications are there matter. After perusal of the same, my lord was pleased to reject my lord at that point of time. Second bill application, my lord.
So kindly consider, Lordship. They will test the trial, Lordship. If they have committed the
No,
crime.
way in your second bail application, you have to
My lord, new grounds, my lord.
show
So-
new
so that
grounds.
is new grounds. After filing, I am coming after filing the search sheet, Lordship.
That is not new ground in favor, so.
The earlier reason I was not there in the petition, Lordship. I don't know what the grounds were taken by this conducting conceal, Lordship, in that case, Lordship.
That cannot be new ground in your favor. Because charge sheet has been filed against you.
Lordship,
No. Heard,
kindly, Lordship.
heard Mr. B.K. Gogoi, learned counsel. Can you show some authority that filing of charge sheet is a new ground in consideration of and second anticipatory bail application.
Earlier, Lordship, it was not a dare, Lordship, we were murdered, one
No,
eighty-nine.
do you have some authority? Otherwise, it is heard Mr. B.K. Gogoi, learned counsel for the petitioner. Also heard Mr. K. Basho, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioners, namely 1, 2, 3, 4, 5, who are apprehending their arrest in connection with John IPS case number 37/2025 under section 61 within bracket 2/189 within bracket 2/30103 within bracket 2 of the BNS. Before filing this bail application, the petitioners had approached this court by filing a connected bail application, which was rejected, which was dismissed after perusal of the case diary. Learned counsel for the petitioner has submitted that since the petitioners had earlier approached during the pendency of the investigation, and now the investigation has completed and charge sheet has been laid. Hence, their custodial interrogation may not be necessary in this case. He submits that filing of a charge sheet may be regarded as a new ground for consideration of this instant anticipatory bail application. On the other hand, learned additional public prosecutor has vehemently opposed the grant of bail to the present petitioners on the ground that offense involved in this case is a grave offense of murder of one Dibbojyoti Kutum by the petitioners. He further submits that since this court had rejected the earlier application for bail after finding sufficient incriminating materials against the petitioners, and since charge sheet has already been laid against them, finding sufficient incriminating materials against them, they cannot take advantage by remaining absconding during investigation and approaching this court seeking anticipatory bail on the ground that charge sheet has been laid. I have considered the submissions made by learned counsel for both sides. It appears from record that the case, the instant case revolves around the accusation that the present petitioners had assaulted the husband of the first informant on 2/5/2025, as a result of which he has sustained serious injuries on his person and ultimately succumbed to his injuries. Stop. It appears that while considering the application for bail, which was filed, application for anticipatory bail, which was filed on earlier occasion by the petitioners, this court has gone through the case diary and found sufficient materials against the petitioners. The completion of charge sheet, the completion of investigation and laying of charge sheet may not be the only ground on which an application for bail may have to be considered. The role played by the petitioners and nature of accusation made against them is also a factor to be considered while considering an application for anticipatory bail, that too, which was moved for the second time. In the instant case, the petitioners remain as absconder during the period of investigation, and after finding sufficient materials against them for their role in killing of the husband of the informant. Stop. This court is of opinion that mere filing of a charge sheet may not be considered as a favorable condition on the basis of which bail may be granted to the present petitioners. The petitioners have failed to show any other new ground for which this bail, anticipatory bail application should be favorably considered. For reasons mentioned above, the application for bail, the instant application for anticipatory bail is hereby dismissed.
Right. Then 13 and 14. May I please, your lordship? My lord, subsequent application, my lord, and on last occasion, my lord, when my lord, my bail prayer was rejected, it was observed that my lord, two material witness named Ghazi Rahman and Jahangir Alam, my lord, were not examined. Now, my lord, they have been examined.
Report has come. Some report was called for.
Yes, my lord, that both my lord, of them, my lord, have been
Okay,
examined, and I have annexed, my lord, and one copy is already available with me, my lord. Record also will reflect the same, my lord. And
Jahangir Alam has been examined.
yes, my lord, Qazi Rahman also has been examined.
Okay.
I have the copy. And my lord, second submission is that, my lord. In the meantime, my lord, another my lord, co-accused, my lord, who was arrested by same forwarding report, my lord, he has been granted bail by this honorable court. My lord, page 83, my lord. My lord, two Rafiqul Islam are there in this case, my lord. Page 83, my lord.
On the ground of arrest.
Yes, my lord. Grounds of arrest, my lord, were not communicated because in my case also, same, my lord. I have, my lord, kindly turn to page 82.
Where is your earlier rejection order?
Earlier rejection order, my lord, page 95. This ground, my lord, was not taken in earlier occasion, my lord. Page 95.
How many days you are behind?
My
the
lord,
curve?
2 years, my lord, 4 months. And following incarceration is also there, my lord. 16 witnesses have been examined out of 40, my lord.
Yes.
Yes, my lord, here, my lord, as because on the point of ground of arrest, my lord, that I am not, my lord, submitting, my lord, in details, my lord, because already, my lord, settled position is there. And my
Ground
lord,
of arrest as well as
my lord,
those witnesses,
my lord, material.
material witnesses have been examined.
Example. My lord, that report, my lord, I didn't notice, my lord, whether, my lord, that report was, my lord, by heritage. That I didn't notice, my lord, otherwise. My lord, regarding the, my lord, ground of arrest, my lord, already, my lord, regarding one co-accused, my lord, that is Rafiqul Islam, my lord, passed the detailed order, my lord, that is on, my lord, 7/8/2025, my lord. Where, my lord, at that point of time, my lord, the contention of the, my lord, the prosecution is that, as because, my lord, this arrest is, my lord, prior to the, my lord, that is of, my lord, Pankaj Bansal, my lord. The Pankaj Bansal's, my lord, that was, my lord, passed on, my lord, 3/10/2025, my lord. So, my lord, after that only, my lord, this consideration will come, my lord. That was the submission, my lord. My lord has already, my lord, in detail way, my lord, described. Now, my lord, after our division bench judgment, my lord, that is in, my lord, NIS matter, my lord. My lord, regarding, my lord, that is the conflicting of this judgment, my lord, that is described, my lord, in, my lord, that is the National Insurance Company and Panoy Safety's case, my lord. If, my lord, there is a conflict on that part, my lord, then, my lord, earlier, my lord, that is the equal strength, my lord, the earlier order, my lord, that is the judgment authority, which was relied, my lord, that was, my lord, taken, my lord. Because, my lord, this entire thing regarding, my lord, there is a violation of Article 22 arising first, my lord, that is in the Pankaj Bansal, then, my lord, Probir Purkayastha, then, my lord, the Bihan Kumar, then, my lord, it is continues to the Kasi Reddy Upendra Reddy's case, then, my lord, to this, my lord, Darshan, and, my lord, thereafter, my lord, the last one, my lord, I forgot, my lord, yeah, that, my lord, that was also, my lord, provided now. So, my lord, only regarding, my lord, ground of arrest, my lord, our submission is that, my lord, as because, my lord, the stand is very clear, my lord. It is from the, my lord, that is, my lord, if, my lord, regarding, my lord, Bihan Kumar and the conflict between the, my lord, that is the Pankaj Bansal will come, my lord. Then, my lord, in this case, as because the arrest is before, my lord, 3/10/2000, my lord, 23, my lord. So, my lord, in this case, my lord, that is not a violation regarding, my lord, the communicating these grounds of arrest, my lord, as, my lord, prescribed in the case of Probir Purkayastha and, my lord, that is of, my lord, in the case of, my lord, Bihan Kumar, as because the word henceforth is, my lord, there.
No, henceforth is not there in Pankaj Bansal. It is
My
in
lord.
some other case.
And that has been already observed by your lordship. And
My
one, my
lord,
lord,
henceforth
No,
word is
if you
there. in, my lord,
interfere, I
Pankaj-
will reject the bill. Without hearing you, I will reject the bill. If you interfere.
My lord, that henceforth word is there in, my lord, this Pankaj Bansal. If only that parameter.
Not in Pankaj Bansal.
Yes, my lord, that is.
Clarified by Ramkishore.
Yes, it has been clarified in.
Clarified, but, my lord, that word is there in Pankaj Bansal. And that is the, my lord, the first time, my lord, this issue came, my lord.
So this incident occurred prior to
Prior to, my lord,
Pankaj Bansal.
prior to Pankaj Bansal, my lord.
So
That is the
ground of
arrest,
arrest
my lord.
is not a ground.
My lord, at that, because, my lord, it is before that. That is our, my lord, submission.
Okay.
Because now, my lord, that is the conflicting, if, my lord, that is the equal strength, my lord, that is, my lord, already, my lord, decided by honorable
And
division judge,
regarding the fact that
my lord,
two witnesses, material witnesses,
my lord.
who were not examined when the prayer for bail was rejected
My lord,
earlier, now they have been examined.
my lord. On that point, my lord, I leave it to your lordship, my lord, because otherwise, my lord, on that point, that is our submission, my lord. Rest is, my lord, on the merit part, my lord, already, my lord, these are rejected prayer, my lord, or detailed order was passed, my lord. And that thing, my lord. So on that
Yes.
point, my lord,
Anything?
My submission is also the same as the learned PPO lordship, because since the arrest was prior to Pankaj Bansal, so the law that held the field at that point of time, your lordship, that was complied with. And also the mandate of Article 22 speaks of the information to the accused, your lordship, regarding the grounds of arrest. It doesn't say that it has to be communicated in writing, your lordship. And as per the, in regard to the material witnesses being examined, your lordship, I leave it up to your lordship's discretion.
Okay. Heard. Mr. S.H. Sikdar, learned counsel for the petitioner, Also at Mr. K. Bashir, learned additional public prosecutor. As well as Miss M. K. Brown, learned counsel for the learned legal aid, learned amicus curiae appearing for respondent number 2. This application under section 483 of BNSS has been filed by the petitioners, namely by the petitioner, namely Rafiqul Islam, who has been detained behind the bars since 4/7/2023 in connection with special case number 80/2023 arising out of this Dhubri PS case number 266/2023 under section 365/365DA/306 of IPC, read with section 6 of the POCSO Act, presently pending in the Court of London Additional Sessions Judge, come Special Judge Dhubri, POCSO Dhubri. This, prior to filing of this bail application, the petitioner had approached this court on earlier occasion also. However, after considering the submissions made by learned counsel for the parties and after going through the materials on record, the prayer for bail was rejected at that point of time by order dated 5/2/2025 in bail application number 2823/2024. Learned counsel for the petitioner has submitted that the petitioner has been languishing behind the bars since how many? For last
3 years, 2 years, 4 months.
for last 2 years, 4 months. He further submits that one of the co-accused who has been released on bail,
My lord, Rafiqul Islam, he is also.
one of the co-accused, in the meanwhile, has already been released on bail by this court in bail application number 3850/2024. Sorry. By order dated 7/8/2025 in bail application number 3850/2024. Learned counsel for the petitioner has submitted that on the earlier occasion, prayer for bail was rejected by this court mainly on the ground that two of the material witnesses in the case, namely Jahangir Alam and Ghazi Rahman, were not examined at that point of time. Stop. However, now whether they have on what basis you are saying?
My lord, I have annexed one, my lord, statement, my lord, and another, my lord, I have, my lord.
However, he submits that the said witnesses have already been examined by the trial court. And in support of his submission, he has produced the deposition of said witnesses before this court. He further submits that the petitioners, that the present petitioner has also taken the ground, an additional ground, that is non-communication of the grounds of arrest at the time of arrest of the present petitioner. He submits that the co-accused Rafiqul Islam has been released mainly on the ground of non-compliance of the requirement of furnishing grounds of arrest in writing to him at the time of his arrest. And therefore, he is also pressing additionally on the same ground for seeking his release on bail in this case. He further submits that there are total 40 prosecution witnesses in the charge listed in the charge sheet, and only how many have been examined?
Report is 16.
On only 16 of them have been examined, and it will take much time to examine all the listed witnesses.
17.
17. So he therefore submits that the petitioners may be allowed to go on bail. He further submits that the petitioner is ready to abide by any condition imposed on him while granting bail to him. On the other hand, learned additional public prosecutor vehemently opposed the grant of bail to the present petitioner in this case on the ground that the offense involved in this case is heinous in nature, and the heinous in nature for stop. He further submits that the ground of non-communication of
Grounds of arrest, my lord.
grounds of arrest to the petitioner in writing may not be applicable in the case of present petitioner, as he was arrested on 3/10/2023. That is
Before that, before 3/10/2020.
when he was arrested.
3/10/2020.
He was arrested on 4/7/2023. That is before the judgment of the apex court
My lord.
in the case of
Pankaj,
Pankaj Bansal versus, what is the citation of Pankaj Bansal?
my lord. This, my lord, Pankaj Bansal versus Union of India and others, my lord.
Union of India and others,
2024-7 SCC 576.
2024-7 SCC 576. He further submits that in a subsequent judgment, that is, what is the citation?
My lord, providing my lord. Yes. My lord, that is our honorable division bench.
No, not division bench.
My lord, on the Panoy Settle's case, my lord.
Uh-huh.
No, my lord. Which my lord?
Ram Kishore Arora.
Ram Kishore.
Case 88, my lord, it has
In 2020.
In a subsequent judgment, that is
Ram Kishore.
Para 88, page 88, my lord. Your lordship will have, my lord.
the case of Ram Kishore Arora versus Directorate of
Enforcement
Enforcement
reported in
reported in
2024-7 SCC 599.
the apex court has clarified that use of word within bracket, within inverted comma, henceforth in the judgment of
Pankaj Bansal.
Pankaj Bansal within bracket Supra by the Apex Court imply that the requirement of furnishing written grounds of arrest requirement of furnishing grounds of arrest in writing would be prospectively applicable only from the date of the judgment in the case of Pankaj Bansal Supra, that is 3/10/2023.
Right.
And therefore, he submits that the petitioner is not entitled to get benefit of bail on the said ground.
Right.
Stop. Learned amicus curiae, Miss M.K. Brown also submits in similar lines to that of learned public prosecutor. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record.
Pleasure.
It appears that this court has already released one of the co-accused, namely Rafiqul Islam, on bail on certain terms and conditions. Stop. It also appears that the bail of the present petitioner was rejected earlier, mainly on the ground that two material witnesses, namely Jahangir Alam and Ghazi Rahman, were not examined at that point of time. Further, from the documents available before this court, it appears that those witnesses have already been examined. Stop. In addition to that, this court also has taken into consideration the fact that the petitioner is languishing behind the bars for last 2 years, 4 months, and all the material witnesses have been examined. Hence, if the petitioner cooperates in the trial and abides by the conditions which may be imposed while granting bail to him, this his continued detention may not be necessary for fair completion of the investigation. Stop. This court is therefore of the considered opinion that the petitioner is entitled to get bail for the reasons stated above. Stop. As the petitioner has already been found entitled to be released on bail on aforesaid ground, this court refrains itself from discussing the other ground on which bail was sought for by the petitioner, that is non-communication of grounds of arrest. Stop. For the aforesaid reasons, the petitioner is allowed to go on bail of ₹50,000 with 2 sureties of like amount, subject to the satisfaction of learned Special Judge Oxford Dhubri with following conditions. Condition page 89 or 1, 2, 3, 3 conditions.
Hello.
And another matter?
Yes. Another is, my lord, that is Zohirul, my lord. Same, my lord, same accused, my lord.
It is a fresh bill
But it is a
application,
fresh
earlier
bail
not
application, my
rejected.
lord, not earlier rejected.
And I am the abettor of the ship, not physically committed the crime. Similar prayer.
Any submission?
Only
My lord,
two
in
change.
Date of arrest,
Date of
date
arrest,
of arrest is, this is
same
also my lord
Lordship.
prior to Banchal, my lord.
second July of 2023, and item ported in 4th July. 2 days later, arrested 2 days before.
that condition দিব, any violation of the above conditions would be sufficient ground for cancellation of bail granted herein above. In this case, you have taken steps for issuance of notice.
If you have served the copy, Your
You
Lordship,
have been appointed.
as per earlier order, Your Lordship. My case earlier listed in other courts, Your Lordship. Thereafter, after take, listed before this honorable court. Your Lordship.
Heard Mr. A.R. Karim, learned counsel for the petitioner. Also heard Mr. K. Bashir, learned additional public prosecutor, as well as Miss M. K. Brown, learned amicus curiae appearing for respondent number 2. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Anar Hussain,
Johirul Islam.
namely Johirul Islam, who has been detained behind the bars since 2/7/2023 in connection with special POXO case number 180/2023, corresponding to Dhubri PS case number 266/2023 under section 365/376DA/306/34 of the Indian Penal Code, read with section 6 of the POXO Act. The gist of accusation in this case is quote para 3 from page 84. What are your grounds?
Ground of arrest not communicated, Your Lordship, and I am not committed the crime, Your Lordship, only allegation to abet the crime. And main accused, one row people, both are row people. I am accused number 3. Page 22 at bottom, Your Lordship, clearly started.
Learned counsel for the petitioner has your name is Johirul,
Johirul, Your Lordship, accused number
but
3.
there is accusation that
Yes.
you have raped.
And the FIR is separate, Your Lordship, in charge sheet. That is a different view, Your Lordship. Page 22 on Rofikul, son of Kader Ali, and another Rofikul, son of
Learned counsel for the petitioner has submitted that the petitioner has been languishing behind the bars since 4/7/2023, and he is not the main accused. He submits that allegation against him is of abetting the offense alleged in this case. He further submits that main accused Rafiqul Islam has already been granted bail by this court. He also submits that the grounds of arrest were not communicated to the present petitioner at the time of his arrest, and therefore there is a violation of mandate of Article 22(1) of the Constitution of India as well as section 47 of the BNSS, section 50 of the CRPC. Stop. He submits that the petitioner is ready to cooperate in the trial and also ready to abide by any condition imposed by the court while granting bail to him. On the other hand, learned additional public prosecutor or amicus or submission, okay, same submission
My lord. Because
on
my lord,
ground
otherwise
of
the
arrest.
implications are there on the basis of merit, my lord. It's not a my lord fifth case, my lord. So that's unusually-
पहले वाला कैसे? Stop.
My lord, why, my lord, we are, my lord, that I already submitted, my lord, the relying, my lord, giving stress on Pankaj Bansal's, my lord. Because of, my lord, that is the, my lord, it is already clear in the case of, my lord, this is national.
No, on that ground, I am not
Yes.
guilty. I'm not.
Only that part. Otherwise, my lord, 17 has examined material weaknesses. That part is already submitted.
I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. The present petitioner is languishing behind the bars since
2 years, 4 months,
since
1 day, or 2 days.
4/7/2024 within bracket for last 2 years, 4 months. Stop. Though the accusation made against him is grave, however, already 17 prosecution
17.
witnesses have already been examined, including the material witnesses. And total 40 listed prosecution witnesses are there to be examined in total. Are there. Stop. Hence, the trial is unlikely to culminate very soon. Further, in the meanwhile, 2 of the co-accused, namely Rafiqul Islam and
That also replicates
namely Rafiqul Islam
others names.
as well as Rafiqul Islam within bracket second have already been granted bail by this court. Hence, considering the above facts, this court is inclined to grant bail to the above named petitioner on the conditions that he shall abide by the condition imposed by this court while granting bail to him. Now, for the reasons discussed in foregoing paragraph, the above named petitioner is allowed to go on bail of rupees 50,000 with 2 sureties of like amount, subject to the satisfaction of learned Special Judge Poxo, Command Thubri, with following conditions. Condition same. This bail application is accordingly dispatched.
Item 15.
May I please, your lordship?
Yes, there was call for the prior to that,
Civil
lordship,
receipt,
the case lordship where on 24/8, 3% were arrested lordship from their possession lordship 3.5 grams without container lordship heroin was found along with some tablets and cough syrup lordship of 108 bottles lordship. And thereafter, the case was registered under 21A, 22B and 29 of NDBS Act. And thereafter, after 11 days,
this present petitioner was arrested from his house and house was searched, Lordship, and there 1.37 gram of heroin was recovered from this present petitioner, Lordship. After 11 days of the registering of the FIR, Lordship, and forwarding that arrested 3 persons, Lordship. The ground of arrest says on basis of the statement of co-accused, Lordship. And thereafter subsequently on 15/9, he was arrested on, Lordship, on 4/9. After 15/9, a prayer was made for aiding section C commercial quantity of the NDPS Act, Lordship. Now the problem is that my part is that after 11 days, I was arrested,
C, why C was added?
Lordship,
Why 21C was
because
added?
earlier 3.5 grams were there, my 1.37 and some bottles and tablets were recovered from that earlier person who were arrested on 24/8, Lordship. When all together, Lordship, it was clapped out, Lordship, and thereafter, Lordship, that C has come, and 15/9 prayer was aid for aiding section C. And later on, Lordship, that is when prayer was allowed. Now, the presently the case is registered under commercial quantity 22C, Lordship, 21C. 21C, Lordship.
22.
What is your name?
22C, Lordship.
What is your name? Nazrul?
My name is Nazrul, Lordship. My part is.
Where is your earlier rejection order?
Earlier, not rejected, Lordship, it was withdrawn.
Why?
That Lordship will, order will, on page 64, Lordship.
Okay.
64.
Now what is,
On page 38. Page 38 is the Lordship order, it was withdrawn, Lordship, prior to.
where is the forwarding report?
Forwarding report, Lordship will find on page 23. Okay, can we see the date on 4th September 2025?
Now what is your submission?
Submission, Lordship, my recovery charge was made at my home. I was arrested from there. That is also after 11 days, Lordship. And my quantity is, Lordship, 1.37 gram. And I am under a small quantity. And different place of charge, they were arrested from somewhere else prior to 11 days. And later on, Lordship, at my house, Lordship, in different location, it was charged and 1.37 grams were recovered, Lordship. And my quantity comes under small.
Yes, is there anything to connect him
29.
apart from
I
the
have
state?
gone through that, my lord. My lord, here, my lord, may kindly peruse the CD, my lord. Here the case is there, my lord, during the course of investigation, when, my lord, at a 2 stages, my lord. First stage, my lord, that is he is not available. He is not the FIR name accused, my lord, admitted position. But, my lord, during the course of the, my lord, investigation, when, my lord, he was interrogated, the another co-accused, he stated his name. On the basis of that, my lord, they take the lead, my lord. And the present petitioner, who is the son of a Gaumura of that area, my lord. Now, my lord, he went there, the police team went there and searched his, my lord, house. Where, my lord, from the house, my lord, 15.82 gram of heroin, my lord, suspected heroin. That was, my lord, says, my lord. And, my lord, Caesar witnesses are there,
No,
my lord.
quantity is 1.3 gram, Lordship. That is with container, and after without container is 1.3.
Let him submit.
No, that
15.82,
My lord, 15.82 gram, my lord, less than commercial quantity,
not 1.3.
not 1. My lord, notice there, my lord, I have flag mark, my. So, my lord, that was, my lord, there, my lord, recovered, my lord. And, my lord, case is, my lord, though, my lord, he is arrested, my lord, this progressing, because the, my lord, allegation is that, my lord, he is the main peddler. my
No,
lord.
121C.
My lord, 22C, that order also I have flag mark, my lord. And on the very beginning, my lord, that is not on the basis of this suspected heroin, my lord. That was recovered in the, my lord, in the later part of the, my lord.
With 22C, can he be
22C
linked?
22C, my lord, is added, my lord, because of the, my lord, earlier contraband, my lord. That is, my lord, that is
That was not recovered from his position.
not his, my lord, house, my lord.
And
But, my
whether
lord, his
can
name
he
came
will,
out, my lord, from here, my lord. From the, my lord, interrogations of this co-accused, my lord. My lord, they are relying on Tufan Singh, my lord, Tufan Singh case, and also, my lord, they are relying on the, my lord, regarding insufficient grounds of arrest. My lord, on that part, I don't find, my lord, that it is an insufficient part regarding, my lord, 47 and
Tufan
48
Singh?
clauses. Tufan Singh case also, my lord, relying, my lord.
You have any submission?
My lord, regarding Tufan Singh case and this case is, my lord, something different, because, my lord, if, my lord, that is the quantity, my lord, that is, my lord, recovered, is in a different way, my lord. Now, here is a case, my lord, the source of the, my lord, that is the, my lord, the counseling of the quantity or the person who is alleged with the incident coming out of that, my lord, the FIR is same, my lord. Where, my lord, only the thing is that during the course of interrogation, that is the, my lord, the accused who is, my lord, dealing the, my lord, drugs in the, my lord, that is the roadside, my lord, he stated that he is the person, my lord. In their language, they say the wholesaler from whom, my lord, they used to buy the things. And on the basis of that, my lord, the police team, my lord, went there. And if, my lord, not getting something, my lord, there, and from his conscious possession, from his residence, my lord, that was taken, my lord. And Caesar witness, my lord, stated the same, my lord. Those witnesses are there, my lord. So, my lord, still, my lord, investigation is going on. So, my lord, it come under the, my lord, there is commercial. Otherwise, my lord, it is come not commercial quantity, my lord. And if it is not commercial quantity, rigor of 37 will not come. And on that, my lord, point, my lord, today is 61 days, my
Then he's entitled to
because
get-
then, my
if
lord,
you fail to link him with 22C,
my lord.
then he's
Then, my
entitled.
lord, yes, today is, my lord, 61 days because, my lord, he was arrested on 4/9/2025, my lord. And as
So
of,
is there anything to link him
my
with?
lord, link is that, my lord, my lord, but my understanding, my lord, going through the, my lord, case diary, my lord, that is, my lord, on the basis of the statement made by the co-accused, my lord, when the police team, my lord, that is, my lord, reach there, his house and make the, my lord, that is the, my lord, house search, my lord. Another, my lord, contraventions, my lord, this recovered, my lord. This make a link, that is the allegation made, that from this person, my lord, those are, my lord, bought, my lord.
No,
If,
after,
my lord, from there, my lord, not getting, my lord, anything, my lord, and they came out on the basis of that statement, my lord. No, my lord, that is
no,
material
no,
recovered,
Mr.
my lord.
Bosho, be
My lord,
clear.
my lord,
After getting
my lord,
information from
My lord.
co-accused statement,
my lord.
a search was conducted.
Search was
What
conducted.
was recovered?
My lord, search was conducted and from him, my lord, that is from his house, my lord, 15.82
That is of intermediate
that
quantity.
is intermediate
No, no,
quantity,
it's
my lord.
small lot, page 31 lot, you can see Caesar list lot. Page 31 of my petition lot. He's saying the correct lordship, but with the container lordship, here is clarification has been given lordship detail. Page 31 lordship will kindly see. Of
But
my
there is
petition.
nothing to link with 22C recovery.
My lord, if we, my lord, not connect with the, my lord, FIR, my lord, then it is a case of, my lord, less than commercial quantity, my lord. But, my lord, from where, my lord, I have come to know, my lord, investigating agency come to know, my lord, his involvement, my lord, in this case. It is, my lord, that is the FIR dated 24/8/2025. Based on the, my lord, that is the GD 23/8/25, my lord. And, my lord, he is arrested in, my lord, later part, my lord, that is on, my lord, 4/9/25. If, my lord, no material, my lord, no substance is recovered, my lord, then, my lord, admitted position, my lord. But now that established, my lord, there is a link of, my lord, peddling. My lord. He is also a peddler, my lord.
Heard Mr. S. Munir, learned counsel for the petitioner. Also heard Mr. K. Bosho, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner Nazrul Ahmed, who has been detained behind the bars since 4/9/2025 in connection with Baihata Charali PS case number 217/2025 under section 21A/22B/29 of the NDPS Act 1985 and added section 22C of the NDPS Act 1985. Learned counsel for the petitioner has submitted that on an earlier occasion also, the petitioner had preferred an application for bail, which was registered as bail application number 3031/2025. However, same was allowed to be withdrawn. And the said application was dismissed on withdrawal by order dated 19/9/2025. The gist of accusation in this case is that on 23/8/2025, one H. Kond, SI of Police of Bahata Chareli, lodged an FIR before the officer in charge of Bahata Chareli Police Station, inter alia alleging that on an information received through reliable sources regarding peddling of drugs by one Faridul Islam alias Boga at a
Two more persons.
stop, and where is the FIR?
Page 13, Lordship, is a type copy. So original Lordship will find difficult to read properly. Page 13.
A search operation was conducted and during search operation 108 numbers of tripodylene hydrochloride and codeine phosphate syrups were recovered therefrom. Apart from Faridul Islam, one Riazul Ali and Muhammad Farooq Ali were also arrested in connection with the said case. It is submitted by learned It is submitted by learned counsel for the present petitioner that after 12 days of lodging of the FIR, on the basis of statement of the co-accused persons, the police made a search operation in the house of the present petitioner and found 12 numbers of plastic containers containing brown color powdery substance. He submits that though the weight of the contraband along with the containers was found to be 15.82 grams. However, when the contraband was weighed separately, it was found to be, where is the scissor list?
Page 28, Lordship.
It was found to be only
Original on page
1.37 grams. Learned counsel for the petitioner submits that the quantity of contraband recovered from the present petitioner is of small quantity and therefore he is entitled to get bail. He further submits that there is nothing on the record to link him with the codeine phosphate which were recovered in connection with this case from the possession of the other co-accused persons. He further submits that apart from the statement of the co-accused, there is nothing on record to link him with the contraband seized of which contra with the codeine phosphate seized. What is the citation of Tufan Singh? He further submits that in view of the judgment of the apex court in the case of Tufan Singh versus State of Tamil Nadu, reported in
2021 for SCC 1.
2021 4 SCC page 1, the statement of co-accused cannot be taken into consideration in against an accused of NDPS case unless some other material are there to implicate him in this said case. Stop. Learned counsel for the, on the other hand, learned additional public prosecutor has submitted that the contraband recovered from the possession, how much was recovered? 15.28 is with container.
My lord, that is in the entry, my lord, I did, but my lord, again, I have gone through this, my lord, Caesar list. There, my lord, this was my
On
learned
that
submitted
contraband
without container is what is there.
recovered from the possession of the present petitioner is of small quantity. However, he has been implicated by the co-accused whose statements were recorded under section 67 of the NDPS Act. He further submits that as in view of the information given by the co-accused, contraband was recovered from the possession of the present petitioner. It clearly indicates that the present petitioner is also a peddler. How you link the codeine? For linking codeine, there is nothing.
My lord, here, my lord, that is, my lord, in the FIR, my lord. In the FIR, my lord, that is if the first part of the FIR is that, my lord, when my lord police get the, my lord, the source is there. My lord, they also involved in selling drugs and prohibited cough syrup. The words both are there, my lord. My lord,
No,
when, my
that
lord,
is
they-
the acquisition.
Yes, my lord, and my lord,
What
when,
material?
my lord, material, my lord, when, my lord, they, my lord, says, my lord, they says 108 numbers of, my lord, that is codeine, my lord, 100 ml syrup and 10 mg codeine phosphate, my lord.
Stop.
That was.
I have considered the submissions made by learned counsel for both sides and have gone through the materials available in the case diary, which was produced by learned additional public prosecutor. On perusal of the case diary, it appears that from the possession of the present petitioner, only 1.37 grams of suspected heroin was recovered. Stop. Though it also appears that though the co-accused have implicated the name of the present petitioner in their statement. However, apart from the statement of the co-accused, there is no other material in the case diary to link the recovery of 108 numbers of codeine phosphate cup syrup bottles from the co-accused with the present petitioner. Under such circumstances, this court is of considered opinion that the embargo of section 37 of the NDPS Act 1985 would not be applicable to the case of the present petitioner. Accordingly, he is allowed to be go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned special judge
Rongia Kamrup.
Romia Kamrup with following conditions, 1 and 2. Send back the case diary. This bail application is accordingly disposed of.
Much obliged. Much obliged.
Yeah, please, Your Honor. Firstly,
This appeal is preferred against the order of granting injunction in favor of the plaintiff. If the gist of the case, Lordship, I would like to highlight, Lordship, in a nutshell. The defendant, the appellant before your Lordship, is the proprietor of a Star Brick Industry, which he has been running for last 11 years. Due to his Lordship illness and some inevitable condition, he decided to let it out to the plaintiff from number 1 and 2 for some consideration. For that, on 5/3/2023, one lease agreement was executed between them. As per the terms of the lease agreement, the defendant, also plaintiff respondent, is required to pay 40 lakhs as a rent fees to the appellant per year, Lordship, which is to be cleared on each 28th of February each year.
Yes.
Thereafter, Lordship, the first 40 lakhs has been paid. They run the industry, Lordship. But next year, Lordship, 2024-25, which the rent 40 lakhs was required to pay
40 lakhs per year.
per year, Lordship, which was required to be paid on before 28th of February of that year. That was not paid. I serve a legal notice demanding that amount. Thereafter, he approves, and we have executed a fresh agreement. Initial agreement was for 5 years. That additional lease deed was executed with a condition that each year they will have to clear the annual lease amount from 40 lakhs to 27 lakhs. New revised it is 27 lakhs.
Yes.
It was also stipulated, if they want to continue, they will keep on paying that rent amount, then fresh agreement would be executed between both the parties. Out of that 27 lakh, they have paid only 10 lakhs. Remaining amount they have not paid till today, Lordship. As per the revised agreement, they are also bound to pay the GST amount and other forest royalty amount. They have also not paid, Lordship, during the period which they ran the business. When I demanded, they raised various issues. Cases filed before the police station. I have also filed FIR against them. Thereafter, Lordship, when I, on one day, Lordship, in the month of March, they have abandoned the brick industry and left the places. And finally instituted this suit, claiming that we have obstructed their business. And also they have claimed that 15 lakhs of bricks is lying in the brick industry. And Larned Tile and
What relief they are seeking?
they have relief damage, Lordship, 4,35,60,000, Lordship.
Money suit.
Money, no, damage claim, damage claim. They have claimed damage.
How much?
Lordship, 4 crore.
Damage
Lordship.
against.
Yes.
Oh,
For
damage from you.
damage from me, Lordship.
On what count? Wow.
There are various grounds. The one ground is that I am obstructing his business. So he suffered loss of that amount.
Okay.
And the land.
So suit is pending.
Suit is pending.
What interim relief was granted?
Interim relief was granted. He was allowed to run that for 5 years. Entire 5 years. And also the brick lying in the brick industry was allowed to take over from that area. So far as the brick which he has produced, let them take over, Lordship. I have no objection. But without paying fees, the rightful ownership of the present appellant, how can trial court has disturbed by way of equitable relief of temporary injunction? It is without considering the prima facie case properly. The consideration.
Where is the impugn order?
Lordship, impugn order, Lordship, would find page Lordship 139. The 3 grounds they have discussed, and this is totally perverse, Lordship, record. I am, Lordship, coming. Lordship, page 139, Lordship. Lordship, may I read, Lordship?
No. Read the operative part.
Lordship.
What relief was granted?
Yes. Lordship, page 143, Lordship, find the count. The finding on the prima facie case, Lordship, and other factors.
No, before that,
Operative part, Lordship. Operative part, Lordship,
what
would
was
find one
prohibited?
47. Lordship got it.
Yes,
Last paragraph 40.
yes,
Now-
read 40.
Yes, now since all the three golden principle of granting temporary injunction, that is prima facie case, balance of convenience, and irreparable loss are found to be there in favor of the petitioner. So this court find it fit to grant temporary injunction. Petition number so and so of the petitioner is as such allowed to the extent that opposite party, his main agent, are restrained from disturbing the petitioner from doing the lawful work in course of running the star brick industry like that, preventing their entry in the said brick industry and stopping them from selling the unsold brick till disposal of the main suit. While granting this relief, Lordship, the learned trial court hold that plaintiff respondents are entitled to run that brick industry for 5 years, up to 2028.
No, but that is not the relief which. The temporary injunction
Yes.
has been granted only during pendency of the suit.
Pendency of suit, Lordship. If suit is pending for 5 years, it is amount to granting the final relief. Lordship, may I come to the page 143? The prima facie case has to be from the material on the record, not beyond that, Lordship.
No, we are not going into the question.
Lordship, may I-
Now we'll admit your appeal.
Lordship,
You will file objection
Yes.
when?
I need 4 weeks if
We-
your lordship.
No,
is-
we'll give fixed date.
Lordship.
Let her file objection. Let the injunction petition, this appeal can be heard and disposed of.
Lordship, and till pendency, Lordship, he has already taken out all the bricks, Lordship. Now, without making payment to the lawful owner, he may not be a de facto owner of that property, Lordship, on the basis of that temporary injunction.
Our
So
suit
till
is-
that, till then, the impugn order may be stayed,
No,
Lordship.
in that case, I have objection, lordship. Because they have admitted that we have taken the brick industry for 5 years on rent, lordship.
The dispute is only regarding payment of the
Yes, Lordship.
rent.
If he paid,
Lordship,
Lordship.
already
even-
we have paid and we will submit the documents, lordship. I will enclose all the documents with my objection, lordship.
If Lordship grant me 2
Their,
minutes time, I can
allegation-
show
Their
I can
allegation
show
is that lordship for
from his
lakhs-
plaint that he has not paid. Where is the pleading that he has paid? If my learned friend has show even a single sentence that there is a pleading that he has paid and he is entitled to run that industry for 5 months, I will withdraw my appeal, Lordship. Instantly, I will withdraw.
Otherwise also, it is a question of payment of rent only.
Lordship.
So it is how you will suffer irreparable loss.
Lordship, how,
If
Yes.
during the
if
pendency of
during the pendency,
this appeal,
Lordship, if during the pendency of the suit, I am coming to suit as well as appeal.
suit we will decide in this appeal
Lordship, if during the
whether they are entitled to get.
Sorry, Lordship, it is a suit filed by them. It is his burden to prove that how he will suffer irreparable loss, Lordship.
Yes.
Lordship, in this case, Lordship, I am the rightful owner. If at the end of the trial, his suit is dismissed, who will compensate me for that whole period, Lordship?
He can file a
Ek
suit,
minute,
lordship.
ek minute. He can
He
file
can
a
file
suit.
a
It is
suit.
a probability, Lordship. It is a probability. He will-
Okay,
he will-
okay, let her file.
Lordship, another thing, Lordship. If Lordship satisfied, Lordship kindly grant stay, otherwise not.
No stay at this
And
stage.
this suit, Lordship, and this suit has been adequately compensated in term of money. Where is the irreparable loss? Honorable Supreme Court, in a category of judgment, Lordship, I am just placing one judgment. which is
No,
the-
we will hear this appeal.
Lordship, let it fix in day after tomorrow for hearing on the injunction, my step here. Otherwise, Lordship.
You are ready to make
No,
submission.
This is their petition, lordship. I have to answer to the Annexures, Lordship.
Okay, heard Mr. P. Datta,
PP Dr. Lordship.
P. Datta, learned counsel for the appellant. Also heard Miss
I have filed caveat, Lordship.
Also heard Miss R. Chaudhary, learned counsel for the caveator slash respondent number,
1 and 2, Lordship.
respondent number 1 and 2. How many respondents are
Lordship,
there?
they are performer respondent, their notice may not be required for those, Lordship. I am abandoned precaution they I have made party them. Because main relief has been sought against that plaintiff respondent or 1 and 2.
Respondent number 1 and 2.
As already there are made parties, either they have to strike out the name of the performer respondents, Lordship.
At this stage, for deciding that appeal, Lordship, they may not be required, but
This appeal under order 43 rule 1R 1 within bracket R of the Code of Civil Procedure has been filed by the appellant Abdul Manaf, impugning the order dated 14/10/2025 passed by the Court of Learned Civil the Senior Division Bongaigaon in Miss J case number 47/2025 in connection with title suit number 4114/2025, whereby the present petitioner his main agent, etc., were restrained from disturbing the respondents from doing lawful work in the course of running of Star Brick Industries. And also preventing them from selling the bricks in stocks till disposal of the connected title suit. Since Ms. R. Chaudhary has already appeared for respondent number 1 and 2, no formal notice need to be issued to respondent number 1 and 2. As regards other respondents, the petitioner shall take steps by speed for issuance of notice on the said respondent by speed post within 3 days from the date of this order. Returnable on which date?
the short date I am paying, Lordship.
Suggested date.
And Lordship, I may be allowed to take Dasti also.
Okay. When will you file?
After 2 weeks,
Lordship, let it be only 1 week, Lordship.
No, 2 weeks we are giving specific date.
any date, Lordship. Service is also required to be completed on or before that date, Lordship.
Yes, on 18th of November, returnable on 18th of November. The appellant is also allowed to take steps for issuance of notice on the pro forma respondents through Dasti mode. Stop. In the event of service of notice on pro forma respondent by Dasti mode, the appellant shall submit an affidavit in compliance thereof on the next date fixed. You have received the copy of notice.
Yes, Lordship.
Okay. Learned counsel for respondent number 1 and 2 has prayed for allowing the respondent to file written objection against the prayer of the appellant. The prayer is allowed. They may do so before the next date fixed. List accordingly on 18th of
Lordship is issuing notice in interlocutory application or in
in main
in both the cases.
in both the cases.
In
both, main
in
case
IA
Lordship
also.
admitted.
appeal admitted.
Appeal
Lordship.
admitted. Stop. The appeal is admitted.
Trial court records, your lordship is.
Records may not be necessary. Record would be necessary.
May not be Lordship at this stage, Lordship, because I'll satisfy from the order itself. Till today, Lordship, I can try, Lordship, but
No objection, lordship.
If,
If your lordship is issuing notice whether before 18 service will be completed.
it is, I'll take
no,
the.
if
If
it
it
is not
exists,
I'll
complete.
take the.
Before 18, whether it will be completed.
Let us see,
Lordship.
because he will take steps by Dusty mode also. In IA also, same order. Issue notice with the respondents, fix on 18.
Till then, Lordship, he can operate by paying only that the due fee, because GST, I have received the GST notice, forest also, notice also. I am
Lordship,
not
if I
getting,
do not pay the forest royalty, then forest department will take action against me.
and if
Lordship.
the GST amount he has not paid, GST will issue proceeding against me, Lordship.
Already we have paid 3 installments
Lordship.
of GST amount to his account. I have
Till then, Lordship, I am
all those I will
Till
make
then
from
what?
relief.
What relief?
Till that he can run Lordship, but by making the rent and others.
No, Lordship, in
That is
case,
implied.
Lordship,
No, Lordship can observe, otherwise, Lordship, when
i-
the
If
appeal is
I run,
admitted,
then only I can pay, I can
Lordship.
pay lordship rent to him. Otherwise, if I restrain from operating the industry,
On
no,
18.
he may allow, but he may be allowed directed to deposit the rent, Lordship.
I to the action, key relief beside.
I'm very clear, Lordship. I'm not against his running, Lordship, but I'm concerned with my client that owner will not get any rent and also paying to GST amount, and he's running, get the quit, Lordship, without making.
interim prayer lordship under order 41 rule 5 read with section 151 of CPC. Further operation of the impugn order.
Impugn order.
Yes,
So this can be considered only
by
after.
deciding final appeal itself.
or any other order as Lordship may fit, Lordship. I have added. It does not preclude Lordship of passing the order for deemed fit and proper under 151.
But it is not,
Lordship, lordship,
It
if it
is-
says the impugn order, then
no stay at this,
I have
Merit of-
placed a judgment, Lordship, in this regard, regarding stay.
on 18th.
Lordship, one judgment may kindly be placed. I have placed.
With judgments.
My judgment to discuss, there are judgment to discuss.
So. No, for considering this judgment, the matter has to be heard.
So when Lordship
We
appeal is
have-
admitted,
I
the
have also took the two
impugn order
judgments.
must be Lordship,
Must,
Lordship Supreme Court, I am not taking.
show me,
Lordship, Lordship can file.
Citation for prayer.
show.
Lordship, the matter, Lordship, paragraph 2, Lordship is a fact, paragraph 3. An appeal from this order was preferred in FAO,
Which,
Lordship,
Whi-
paragraph
which-
4.
read para 4.
We have heard S.N. Kerkar, learned counsel for the appellant, and the respondent appeared for caveat from so and so. We are not inclined to examine any. We are not inclined to examine any contention on merit at the operation at present, but we would like to notice the emerging situation. If the operation of the order under appeal is not suspended during the pendency of the appeal, if FAO is allowed, obviously Mulchan Yadav would be entitled to continue his possession. Now, if the order is not suspended in order to avoid any action in contempt pending the appeal, Mulchan Yadav would have to vacate the room and hand over the possession of the audience in the court order. We are in full agreement with Mr. Manoj Swarup, learned advocate for a respondent, that court order cannot be floated, and even a caveat respect of the court order cannot be tolerated. But if order are challenged and appeal are pending, one cannot permit to swing the pendulum continuously taking place during the pendency of appeal. Mr. Swarup may be wholly right in submitting that there is an intentional floating of the court order. We are not interdicting any finding, but judicial approach required that during the pending of appeal, the operation of an order having serious civil consequences must be suspended. More so, when appeal is admitted, previous history of litigation cannot be overlooked. And it is not seriously disputed that whole is building. This is the pen.
Where is that? When appeal is admitted, you have to stay.
That is power lordship.
That is not the law.
We are not interpreting the finding, but judicial approach required that during pendency of the appeal, the operation of the order having serious civil consequences must be suspended.
Having,
More so
having
when appeal-
serious civil
Then-
consequences,
Lordship recovery.
that has to be adjudicated
Lordship. Respect to the facts of this case on.
on 18th.
Lordship, obliged. That observation may be made, he may be paid the lordship the.
On 18th, we will consider.
There is no
Obliged.
power lordship, he can file a separate suit in my
It is
suit
not the
itself.
question. It is
Lordship,
not the
the
question.
counterclaim
So
can
far
be
as
filed.
lordship the civil law limited knowledge, it is not the question. The plaintiff has to prove his case on his own lordship. It is not dependent on the dependent lordship.
You reserve something from for 18th also.
Lordship.
Yes, please, Lordship. Lordship, in this case, I have filed high Lordship for correction of order dated 5/5/2025, Lordship. In RSA Lordship. Lordship, here, Lordship,
Whose order was there?
5/5/2025
5.
in RSA Lordship.
Order dated 5/5/2025 in RSA.
Lordship.
RSA to दियो. Yeah. What order?
Here, Lordship, wrongly written Lordship, respondent number 1.1, 1.2, 1.3, 2.1, 2.2, 2.3, and 2.4, and 2.5. Lordship, instead of respondent number 1 and 2, Lordship. As such, Lordship, I have not able to take a step, Lordship.
Why you are saying it is wrongly written?
Here, Lordship, respondent number only 1 and 2.
No more respondents are there. Okay. Nobody has died. No substitution is there.
That appellant substitute, Lordship, but not respondent.
Okay. What is your name?
P. Udhikari.
P.
Udhikari.
Heard Miss P. Adhikari, learned counsel for the appellant / applicant who submits that, who brings it to notice of this court that though there are only 2 respondents in this appeal, however, this court directed by its order dated 5/5/2025 that notices that steps be taken for issuance of notice on respondent number 1.1, 1.2, 1.3, 2.1, 2.2, 2.3, 2.4, and 2.5 by Dusty Mode. She submits that as only 2 respondents are there, this said order cannot be complied with by the present appellant. Stop. I have perused the records of this case and considered the submissions made by learned counsel for the appellant. It appears from memo of appeal that only 2 respondents are there in this case, and therefore the appellants are directed to take steps for issuance of notice upon respondent number 1 and 2. Additionally, by way of Dusty Mode. Stop. In the event of service of notice by the said board, the appellant shall submit an affidavit in compliance. Thus the mode within 7 days from the date of this order, returnable after 4 weeks. Submit a affidavit in compliance on the next date fixed, list accordingly.
Ship 2977. I was for correction of order.
What is this 2977?
I for correction of order dated 5/5/2025.
Okay. Now, as याद लिखियो, as the no আগৰ order होते गेट दिखाई দিব. In view of the aforesaid order, the I number 2977/2025 is disposed of. A copy of order photo set kori eta original rakhibo eta I
Item 19.
Wait, your lordship. On the last occasion, my lord, we had sought for adjournment to ascertain regarding the step status on the service of notice.
Yes.
I have ascertained, my lord. What I can see is that so far as the service of the miscase is concerned, there's an office note that the service is completed. So in effect, the service is complete upon the respondents.
Miscase is in relation to what?
The stay. It's a second appeal. The defendant appellants, we are defendant appellants. The appeal was admitted on the
But
second.
have you taken steps in
Correct.
main appeal?
If lordship takes up the second part 5, in the second part 5, lordship would have 2 pages where we have flag mark. The second part 5. We have flag mark green and yellow. The lordship would take up the green for a moment. That would be the Talabana which has been taken on the 7 respondents.
In miscase
In
only.
miscase, absolutely. Now, my lord would have the yellow flag mark. And lordship would see, as per the House High Court rules, my lord, written up notice that was taken, and that is for the all 7, 45 into 7. That's on the weight. That says memo of appeal and miscase. So the general one, as well as this one, would be the registered steps were taken. Regardless of this, my lord, the defendants, the respondents are in notice because of the office note that they have received notice of the miscase as well. In effect, they are in notice long back. No difficulty on that score. Only thing is that, if I may say correctly, due to the command over English by asked clerk and how the things went through, this confusion was created. It was taken. It is not taken. But somewhere things fell through. Now I cannot trace out because back those days we did not have these computerized systems.
Now, what do you suggest?
What I would say, my lord,
Because this.
I understand.
It's
Since
long back.
Since that, and that point of time, because written up notice, Talabana, everything went. And the miscase, the stay and the judgment they have got, the notice is complete because the office note says so. Trial court records are there. Suit was, my lord, it was their suit. Suit was dismissed. They came in appeal. Appeal was allowed. So we came in second appeal.
Okay.
It's only whether they are a statutory tenant, my lord, that case was there. That is the only case. Suit was dismissed. Our appeal was allowed. Their appeal was allowed. As against that, the second appeal come on the substantial question of it was admitted. It is not a case that they'll be taken by surprise and I don't know it.
No, in this Interlocutory application for stay.
They have the notice, I presume it's the office note dated. No, no.
Whether stay was granted? No.
Yes. That was granted in MC 2062 of 2010. And the service report is 18th of September. Admittedly stay granted. Even I've checked the guard file below, which says the order was communicated. That's a 41 rule 5.
Now what we can do?
So since in effect, service is completed on them, they know it.
Or on technical ground?
Technical grounds, the technical would come when they are not put to notice or not cause effective service. There's a High Court noting saying that the office says that service is complete. Once the service is complete, then so far as our part is concerned, we have done.
No, but that has to be held by the court that office is service is complete. Office notice.
I presume would have it once it goes to the Lavazima court for a consideration as to whether Order 9 Rule 5 that would come in, or the
Suppose
General
office
Secretary.
office gives a wrong noting.
then it has to go to Lavazima court. Any doubt concerning the office? Here it is not a matter of presumption. This is a case where on the basis of AD
miscasing.
cards. This is on the basis of AD cards. The noting has been made on the basis of AD cards because the office staff would not have the jurisdiction to do so, to draw or not to draw a presumption. That would go to Lavazima court, internally to come here. Long back when we joined practice, around 2 decades back or what, then the matters used to come to the court for the order stage. Nowadays, this is not there. Service is complete. But for some reason or the other, they are not choosing to appear. That's what I could say.
Then we'll fix it for hearing.
Absolutely. But there has to be an observation for my lord that the service is complete by the order, the office noting. And the individual service has been checked and even tagged to the files. I've gone through that in the morning. It may come for hearing in due course. That's okay.
Will you take fresh steps in appeal? Because you took step belatedly.
I presume not. Steps were taken on 2nd of July. And the order is a couple of days prior, 30th of June perhaps. 2nd of July, the steps were taken. Immediate steps were taken in compliance. This is a peculiar case where they have chosen not to respond despite receipt of notice.
In the miscase.
Steps are taken
no,
in a compiled manner. The RSA and the miscase, back then, how it was taken. The RSA and miscase are taken together. Now, once for the general, there will be Talabana. And for the registered post, and now speed post, for the registered post, it will be taken on the weight and measures, and therefore the common writing is there, along with miscase and memo of appeal.
No, from
Then
where?
it is weight.
How this court will come to a fact?
It's not a question of finding, it's a matter of routine. So the section is there. There's a section superintendent to check it out.
So section's note is that
Service is complete.
Steps was taken in respect of miscase only.
That understanding, I do not know how it went through.
Suppose the court issues notice
steps have to be taken on both the main appeal and the miss case. That if someone would not take on the main appeal and not take on there's no choice. We have to take on both. The miss case, the steps has to go, and the main appeal also steps has to go.
But there has to be some materials on record from which a finding may be arrived at that you have taken steps in both the cases.
All right, we'll take steps again.
You-
But one thing may be indicated that despite notice all these years, they have not turned up.
In miss case.
Not only in this case, they take notice of the case. The case has two parts, the RSA and the miss case. They cannot shut their house on the RSA. The miss case arises out of RSA. It's a stay of a judgment.
No. They may think not to oppose your miss case. That may be a stand.
Correct. If that is the stand, then the stay continues, and the stay continues against their judgment, which goes in their favor.
Yes, stay continues.
It's not, I mean, a prudent thinking that there's a stay against me and I'll let the stay continue without appearing in the court. That's not an elementary prudence, my lord. That may not be the thinking, but we'll take steps. Anyways, we'll take steps. But an observation be there that the service is complete, although nevertheless, but they've chosen not to respond. So the technicalities will take steps.
Heard Mr. L. Banik,
Yes, but
S. Banik, Learned Senior Counsel,
not sitting up.
Learned Counsel for the respondent, Learned Counsel for the appellant, who submits that in pursuant to the directions by this court on last date, that is 23/9/2024, he has verified from records, and it appears that the notices issued to the respondents number 1, 2, 3, 4, 5, and 6 were duly served on the respondents. He, however, fairly submits that in the office note, though it has been stated that office note dated 18/9/2024, it has been stated that the appellants have taken steps only in miss case number 2062/2010, wherein stay on execution of the impugned judgment and decree was granted. However, in fact, the appellant has taken steps, have sent notice of both the RSA as well as miss case together by registered post with ID as well as by usual mode. Stop. On perusal of the office note dated 18/9/2024, it appears that notices sent to respondent number 1, 2, 3, 4, 5, and 6 in miss case number 2062/2010 has been duly served. However, it also appears that it reflects that no steps for service of notice on the respondents have been taken in RSA number 129/2010. Stop. Though the submissions made by Learned Counsel for the respondent, Learned Counsel for the appellant, that once notices are sent together, even if the respondent receives notice in miss case, they will have notice of the pendency, about the pendency of the RSA number 129/2010 seems to be reasonable. However, in the light of the however, this court still of the considered opinion that it would be proper to direct the appellants to take fresh steps in RSA number 129/2010 by fresh steps for issuance of notice upon the respondents by speed post within 7 days from the,
Take your time, I'll communicate with the client. also.
within 2 weeks. 2 weeks from the date of this order, returnable after 4 weeks.
Except 4 and 7, Straco file order dated 13/9/11.
Stop. The petitioner, the appellant need not to take steps upon respondent number 4 and 7, as their name have already been struck out by order dated 13/9/2011. List accordingly after 4 weeks.
Obliged.
Item 20.
Please, your lordship, in this matter, we are about to obtain instructions. Lordship, we tried to obtain instruction where there is no response so far. Lordship. So,
Instruction regarding what? This is your case.
pursue the matter, but there is no response from him.
Otherwise, as regards to respondent number 5, I appeared since she died already. My name has been already shown. And I heard that the other person, the petitioner also expired. Therefore, I do not know if
Petitioner also expired.
I only heard it.
Lordship,
I am not sure.
your lordship may kindly grant us 2 weeks time. Anytime, meantime, we will open our necessary instructions.
I'm not sure. Because my person also already expired. I am unable to get any instruction from them. And 2009 matter, 2016 matter.
We'll give a fixed date. Heard, Mr. What is your name?
Argo.
R. Gohai.
Yes, Lord.
Heard, Mr. R. Gohai. Learned counsel for the petitioner. Also heard Mr. B.K. Bhagavati. Appearing for respondent number 5. Who submits that he has heard that the
That
petitioner.
may not be, that may, it will, sometime it will.
No,
be.
at least I'm not giving author. Okay. Otherwise, it will be lingering like anything.
Yes, there is a problem is there.
He will verify whether your information is right or not.
Let them obtain instruction in next date. If they does that, the matter may be dropped.
Stop. Cut it here. It appears from order dated 35/2025 that the counsel for petitioner had sought leave of this court to take instruction as to whether petitioner intends to continue to pursue this civil reason petition or not. However, he submits that some more time may be granted as he could not take the required instructions. Considering the submissions made by learned counsel for the petitioner, the prayer is allowed. Let this case be listed again on 20 November.
21.
Yes.
The lordship, on the last date, we sought time to obtain instructions as to if you want to go for mediation or not. But we were unable to contact the client, hence we require a bit more time, your lordship.
You're for the respondent.
Yes, your lord.
No one has appeared for the appellant on call. Mr. What is your name?
E. Khan, your lordship.
Mr. D. Khan, learned counsel for the respondent, has submitted that some more time may be granted to him so that necessary instructions may be obtained from the respondent, as the respondent intends to go for mediation in this appeal or not. The prayer is allowed. Let this matter be listed after 2 weeks,
4 weeks, Your Lordship, is out of date.
4 weeks on a date to be fixed by the master.
Okay.
Item 22.
It is a Lordship, we have taken steps upon the respondent. Today, my
Today,
the earlier occasion we have taken steps, but the service report was not received, ma'am. So we were directed to take first steps, ma'am, on the legal errors of the sole respondent.
what for these IAs?
So that is for delay condonation substitution. Settlement as a-
771 is delay
Delay
condonation.
We have taken steps on that particular IA member.
Heard Mr. A. Deka, learned counsel for the applicant. He submits that the applicant has taken steps for service of notice upon respondent in person to the directions, earlier directions of this court today only, and therefore some time may be granted. And therefore the service report may be awaited. The prayer is allowed. Let the service report be awaited. List this matter after 4 weeks.
Item 23.
May it please the Lordship. The appeal was already fixed for hearing, this year also there. But in the meantime, I got information that respondent number 1, Roman 1 expired. Accordingly, I filed one application for condonation of delay, that is IN number 2365. And another is for setting aside abatement and substitution. On 17/9/25, this honorable court condoned the delay of 312 days. So in that view of the matter, Lordship, the setting aside abatement, delay of setting aside abatement also may be allowed, and respondent number 1, Roman 1, legal error may be substituted in the main appeal.
You have sent setting aside abatement petition.
That is IA 2366.
You are appearing.
I'm all the respondent, I'm appearing for all the respondent. I have no objection.
Heard. Mr. J, what is your name?
J. Deka.
J. Deka, learned counsel for the applicant / appellant. Also heard Miss
Miss
What?
A. Hussain.
A. Hussain, appearing for all the respondents. This application under Order 22, Rule 9 of the Code of Civil Procedure 1908 has been filed by the applicant / appellant, praying for setting aside abatement of the appeal against the deceased respondent number 1 within bracket 1.
Roman 1.
No. Where are I? Learned counsel for the petitioner has submitted that there was a delay in filing the instant application of 252 days, which has already been condoned by this court by order dated 17/9/2025, passed in IA within bracket C 2365/2025. Stop. The reasons shown mentioned for the reasons mentioned in the application, in the instant application, as well as for the instant application filed by the applicant, as well as considering the fact that the learned counsel for respondent has no objection to the setting aside of the abatement. The abatement of appeal against respondent number 1 within bracket 1 on the death of the said respondent, namely Madan Mohan Vishwas, is hereby set aside, and this interlocutory application is disposed of. Substitution petition.
Two correction is there. One is the delay is 312 days.
312 days.
And this Umananda Biswas is the respondent number 1. Substitution application 2691. Lordship.
Who is the deceased respondent?
Lordship, Umananda.
Umananda Biswas.
Okay.
Para 2, page 9, Lordship. of this
Madan Vishwas ne likhibo, Umananda Vishwas. Next item. 2691. Next interlocutory application. This so and so. This interlocutory application under Order 22, Rule 4 of the Code of Civil Procedure has been filed by the applicant / appellant for substitution of the legal heirs of the legal representatives of the deceased respondent number 1 within bracket 1 in the memo of appeal of the connected RSA number 101/2022 in place of the deceased respondent 1/1. The learned counsel for the respondent has no objection to the said substitution. The names of the deceased respondents, the names of this legal representative of the deceased respondent are as follows. A. Srimati Vinita Bishwas. B. Srimati Shri Vikas Bishwas. C. Shri Nikhil Bishwas. D. Srimati Sibani Bishwas. And E. Srimati Dulali Bishwas. Stop. The names of the aforesaid legal representative of respondent number 1 within bracket Roman 1 may be substituted in the memo of appeal of the connected RSA as respondent number 1 within bracket Roman 1 A, again within bracket A, then comma 1 within bracket Roman 1 B, similarly C, D, and E. Stop. The applicant / appellant shall file the connected cause title of the memo of appeal within 7 days from the date of this order. This interlocutory application is accordingly disposed. Main to nullity. May not order 1 I 2. I listing 1
Main case will be listed up. this correction.
The connected RSA shall be listed after submission of the corrected memo of appeal, corrected cause title of the memo of appeal by the appellants after a week.
Obliged. Item 24.
We've taken steps. This, but the report is of earlier steps. Lordship, it shows that respondent number 2 and 3, they have left the address.
This reports is, you have gone through the office note.
Lordship, the service report I have gone through. 31/10/2025.
Yes,
Yes, the Lordship, the address could not be obtained, Lordship. We pray to apply for substituted paper publication.
in respect of respondent number
2 and 3, respondent number 2 and 3.
2 and 3, okay.
Rest our service has been completed as per order dated 8/1/2025. It has been replied.
Okay, what is your name?
T. Majumdar.
Heard Mr. T. Majumdar, learned counsel for the appellant. What for the IA is there?
It's for stay.
Learned counsel for appellant / applicant. On perusal of the office note dated 31/10/2025, it appears that notices issued to respondent number 2 and 3 could not be served. And it has been reported that the said respondents have left the place of which left the place, address of which was mentioned in the notice. Top. Learned counsel for the appellant submitted that as the appellant is unaware about the new address of the said respondents, they may be allowed to take steps by way of substituted mode of publishing the notice in a newspaper. In two newspapers.
In both languages, sir.
Yes. The prayer is allowed. The appellant shall take steps for issuance of notice by publishing same in two newspaper, one in vernacular and one in English. Circulated. What was the address of the
It's in Kamrup Metro only.
circulated within this state of Assam? Within the state of Assam, the appellant shall take steps within 15 days from the date of this notice, date of this order. The date of notice, date of appearance to be given in the notice shall be first of December. First of December. List this case again in the second week of December.
Item 26. Please, Your Lordship. Lordship, white order dated 22/4/2024. This first appeal was admitted and we are directed to take steps on respondent number 1 and 2. The scan copy of the TCR was also called for. But white order dated, white office note dated 5/11/24, Lordship, record has not been received yet. And there no mention, service report is not reflected in the office note.
Third, Mr. What is the name?
W. Hawk.
W. Hawk. Learned counsel for this is item number
26.
W. Hawk, learned counsel for the appellant. Also, Mr. N. Hawk, learned counsel for respondent number 1 and 2. On whom the service is still awaited.
This is complete then, Lordship. Yeah, great, Lordship. But it is not reflected in the.
No, now no necessity
No, no, sir.
because he is appearing. Stop. From the office note dated 2/5, sorry. (5/11/2024), it appears that the records of the trial court which were called for have not yet been received. The registry to issue take steps for requisitioning the aforesaid record. List this matter again after 4 weeks on receipt of the trial court records.
Item 27.
Lordship, as per the office note, LCR has been received and the service is also complete, Lordship.
Heard Mr. A. Singh, learned counsel for the appellant. You are for? What is your name? Heard Ms. D. Gogoi, appearing for respondent number 1. It appears from record that the records of the trial court have been received and the appearance of parties is also complete. Hence, this case is ready for hearing. Let this matter be listed for hearing after 4 weeks on a date to be fixed by registry.
Obliged, Lordship.
Item 88.
May I please, your Lordship. Respondent has appeared, your Lordship, and TCR has also received.
So, heard Mr. A. R. Shom, learned counsel for the petitioner, learned counsel for the appellant. Also heard Mr. A. K. Gupta, learned counsel for respondent number 1 and 2. Since the appearance of parties is complete, as well as the records of trial court have been received, let this matter fixed for hearing after 4 weeks on a date to be fixed by registry.
Obliged, your Lordship.
29 to 31.
In this case, my lord, the LCR has been received, but the office note has stated that the service has not been completed. But I have consignment check report, and it may come up after 7 days. I will file affidavit along with the consignment.
Heard Mr. R. K. Jain, learned in item number
29, 30, 31.
29, 30, 31, common order. Order sheet shall be in all the cases, huh, Amita? Heard Mr. R. K. Jain, learned counsel for the appellant. On perusal of the office note dated dated. Where is the receipt of the trial court records? Trial court records have not yet been received. It appears from records that the trial court records have been received. However, office note dated 31/10/2025 shows that the notices sent to respondent number 1 and 2 have not been received. On this, learned counsel for the appellant submits that he may be allowed to submit postal track consignment report of the notices sent to the said respondent by
Showing service of
registered post with AD showing service of notice upon the said respondent and prays for listing this matter after a week. The prayer is allowed. Let this matter be listed after.
it may be put.
Let this matter be listed again on 11th of November.
May I please, your lordship? As per office note dated 25/7/2025, lordship, service is awaited, lordship. So lordship, press step may be taken, lordship.
Heard, Mr. What is your name?
M. Hussain.
M. Hussain, learned counsel for the petitioner. On perusal of the office note dated
25/7/2025.
25/7/2025, it appears that notices sent to the respondent by registered post with AD has not yet been received back. Stop. The petitioner shall take fresh steps for service of notice upon the respondent by registered post, by speed post, as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks, list accordingly.
Interim order first earlier shall be continued.
The interim order shall continue till next day.
Deeply obeyed.
Then 33. As per office note dated 6/8, notice has been served upon the sole respondent.
Duly served. Has been served.
Yes, office note 6/8.
Heard, Mr.
M. Gogoi.
N. Deka,
M. Gogoi.
M. Gogoi, learned counsel for the appellant. On perusal of the office note dated 6/8/2025, it appears that the notice issued to sole respondent has been shown to be served by the report of the process server. Stop. The notices issued to the sole respondent is therefore held to be duly served. However, the records of money, however, it appears that though the records of the first appellate court has been received, however, the records of money suit number 21/2007 has not yet been received from the trial court. Issue fresh requisition for the same. Registry, issue reminder for the same. Registry to take steps. List this matter after 4 weeks.
Not before hearing.
After receipt of record.
34.
Although these steps were taken upon the respondent. Respondent number 2 have appeared, my lord.
For respondent number 2,
But as per the office note, my lord, respondent number 1 is not a resident of that address number on which we have taken steps. And today we have received that he has shifted to Tinshukiam instruction. My lord. So I might be allowed to take steps upon that particular address. My lord.
You have to first intimate the new address.
Yes, ma'am. That by way of an IM, my lord,
Or you take steps on the new address. Address you have to intimate to the court that heard Mr. A. Deka, learned counsel for the appellant. Also heard Mr. A. Chaudhary, learned counsel appearing for respondent number 2. From office note dated 2012-2024, it appears that the notice issued to respondent number 1 has returned with a report that the respondent has left the said address. Stop. In view of the same, learned counsel for the appellant prays for some time to get instruction about the proper address of the respondent number 1, as the petitioner, as the appellant has been informed that respondent has shifted to Tinsukia. The prayer is allowed.
One more prayer, my lord. May call for the record. PCR.
The prayer is allowed. The record will not call for earlier.
Call.
Prayer is allowed. The appellant shall take the necessary instruction as regards new address of the respondent number 1. It also appears that by order dated 12/6/2024, this appeal was admitted. A substantial question of law was formulated by the court. However, records of the first appellate court as well as trial court were not requisition. Stop. Let the same be called for. Registry to take steps for requisitioning the trial court as well as first appellate court's record. Please this matter after 4 weeks.
All right.
45.
Yeah, Peter Lordship. Lordship, the office note reflects that the service has been completed and the records have also been received.
Heard Mr. G. Bhardwaj, learned counsel for the appellant. On perusal of the office note, this is item number
35.
perusal of the office note, it appears that the engaged counsel for the respondent, how many respondents are there?
11.
Respondents have filed their wakalatnama. And it also appears that the trial court records, I say, wrong.
The office note says that the records have been received.
The records have been received. However, the records are not found along with this record of this appeal. Hence, the registry to verify as to whether records have been received or not and put up an appropriate records of trial court as well as first appellate court have been received or not and put up an appropriate note before this court on in the next week on a date to be fixed by registry.
46.
May it please your lordship. Lordship, my senior is feeling unwell. Lordship, my senior is left the court. Kindly adjourn the matter for today.
And for the sole respondent.
What is your name?
Islam. I'm for the Endash.
Heard Mr.
Islam.
A. Islam, learned counsel for the respondent. Also heard Mr. What is your name?
Appellant, your lordship. I'm for
H.
the-
Agarwal, Lordship, on behalf of the.
H. Agarwal, appearing for the sole respondent on perusal of the office note dated 20. Records I sent, 29/4/2024, 5. It appears that the records of the appellate court, first appellate court, as well as trial court have not yet been received. Registry to issue reminder for the same. Please this matter after 4 weeks after receipt of the aforesaid records.
The difficulty is, Lordship, they have also filed a petition for stay of the execution of the impugned judgment, Lordship. So since it's a money decree, Lordship, there is a provision of Order 41, Rule 1 for payment of the security amount. Since the delaying there, they just filed a petition appeal and.
But whether
delaying the
any
process.
stay has been granted,
No, since stay has not been granted.
then you can go for execution.
Service report is awarded, Lordship.
Heard, Mr.
There is a delay, Lordship, 204 days. H. Islam, Lordship.
How many respondents are there?
One response.
Heard,
H. Islam.
Mr. H. Islam, learned counsel for the applicant. On perusal of the office note dated 1/9/2025, it appears that notice issued to the sole respondent is complete. Stop. In view of the on perusal of the office note mainly cable, on perusal of the order dated 1/9/2025 passed by the Lavazima court, it appears that notice issued to respondent number 4 is complete. Let this interlocutory application be listed again in orders column on 12th of November.
Item 48.
Yes.
May I please, before Lordship, in this case, it was taken, but as per Official 2710, service has not been completed, but we are able to get postal treatment concern that was reflected as service completed before about 2 months ago.
You submit that by filing an affidavit. Heard.
Mr. SZB.
Mr. What is your name?
SZB Aklas.
SZB Aklas, learned counsel for the appellant. Also, it appears from the office note dated
2017.
27/10/2025 that service report in respect of notice issued to respondent number 1 and 2 has not yet been received. Stop. It also shows that the trial court records have been received. Stop. The registry is directed to place the track consignment report, postal track consignment report of the notices issued to the respondent number 1 and 2 by registered post on the next date fixed. The appellant may also file an additional affidavit bringing on record the postal track consignment report. Let this matter be listed after a week on a date to be fixed by registry.
39.
May I please the lordship?
So as per office note dated 30/10/25, the address he could not be found in his address. Possibly, lordship, I have to seek some instructions regarding his new address.
How many respondents?
Only one sole respondent.
Heard Mr. D. Majumdar, learned counsel for the appellant. On perusal of the office note dated 30/10/2025, it appears that notice issued to the sole respondent has returned without service. Notice issued to sole respondent by usual mode has returned without service. Whereas the notice issued to the said respondent by registered post with AD has returned with a report that addressee could not be located. So in view of the above, the learned counsel for the appellant has sought for some time to get instructions as regards the proper address of the sole respondent.
Hello, there's an IA, there's an interim order was passed on 23/5/25 that we extended.
The prayer is allowed. Let this matter be listed again on 25th November 2025.
That's all right.
In I entry. In IA, similar order like that of only addition would be the interim order passed earlier shall continue till next day.
14.
May I please the lord? But at the office note dated 27/10. Some of the respondents have filed their Ukalat number. So far, the respondent number 2, Roman 1 and 2, Roman 3 are concerned now. They have expired. So I have already filed an application to bring the record, legal errors on record. But that application is not on the tag.
Heard Mr. G. Bhardwaj, learned counsel for the appellant. Also heard Mr. What is the name? M. Ahmed, appearing for respondent number
1, 2.2, 2.4, 2.5, 3 and 4.
Likha. It appears from office note dated 27/10/2025 that the notice issued to respondent number 2.1 and 2 within bracket 1 and 2 within bracket 3, Roman 3, 2.1 to be Roman 3 में होगा. 3 have returned without service and stop. Learned counsel for the appellant has submitted that. In the meanwhile, the appellant has filed an interlocutory application to bring on record the legal heirs of respondent number
2, 1 and 2, Roman 3.
2.1 and 2 Roman 3. However, said applications are not placed with this case record. Hence, the registry is directed to place the aforesaid interlocutory application along with this record after 2 weeks on a date to be. Government is there.
Respondent number 5.
Show the presence of Ms. D.D. Burman, learned additional senior government advocate appearing for respondent number
5.
5. list accordingly after 2 weeks. The registry is directed to show the name of learned government advocate. Learned government advocate Assam as the council for respondent number 5 in the cause list henceforth.
We have taken steps, Lord Sir. The report has, I'll have a copy, Lord Sir.
I'm not reflecting it
I'll
in
have
your.
a copy by tomorrow. I'll.
Item 51, my lord, my name just, my lord, shown in the post list, my lord. I am for the petitioner, my lord. K.U. Ahmed.
Item 51. Item 51. Registry is directed to show the name of Mr. K.U. Ahmed, learned counsel for the
Appellant petition.
appellant in the cause list henceforth.
And the date may be, my lord,
No other matter hence left over.
Item number 54. It's a part hard matter. Lordship has already heard. Lordship has directed us to file written argument. Both sides are ready with written argument. May I submit it?
Yes.
Lordship may kindly-
Item number 54 likhiwo. Heard Mr. S.K. who is
He is for the appellant.
heard Mr. R. Sharma, learned counsel for the appellant. Also heard Mr.
A. Bhattacharya.
A. Bhattacharya, learned counsel for
Respondent one.
respondent. Both the learned counsel have filed their written gist of respective arguments. Same shall be tagged with the record. Hearing concluded, judgment reserved.
well, next item, I think 41 to 50, the series, land acquisition matter, any date may be fixed, my lord. Otherwise, matter is since 2019, the payment has not been given to the claimant.
Date, the court master will find out our dates. 51 to 90. Or
41 to 50.
then registry has to give date. Because for court master also it will be difficult. These matters will be shown as leftover matter. You pray before the registry.